Can you hear us out there in Zoom land?
I can hear you, Ron.
Excellent.
I'm good.
Heidi, you want to test your mic?
Test.
Okay.
How's that?
Is anybody here from Ardella?
Ardella apparently told you yesterday she wasn't going to be here today.
She was going to send an email, but only because she was busy in the treasurer's office.
Yeah, she's busy in there.
Okay.
She said she would not be here. I believe you got that message.
After she responded, this was her preference. Okay,
I don't speak for
let's
Della.
call this meeting to order at 9:03 a.m. Good morning, everyone. Thank you for joining us. Roll call when ready.
Glenn,
Here.
Goss, here, Pop,
Here.
Bauman,
Here.
Bennett is absent.
Any changes to the agenda?
No changes without a full board. Special meeting.
Any conflicts of interest? Okay, and everybody's favorite part of the meeting, public comment. Anyone out in Zoom land who would like to make a public comment, if you use your cursor and kind of hover over the bottom, 5% of the screen or so, you can see a raise your hand icon just right of center of the screen. You can click on that and your an electronic hand will be raised, or you can just do something like this if you're on video, and we'll get the idea you would like to make a public comment. So while that all takes place, we'll entertain public comment here in the Township Hall. Good morning. Anyone here in the Township Hall like to make public comment?
Good morning. My name is Vicki Beam. Is this on? Yep. Vicki Beam. I'm a resident of Whitewater Township. First of all, Ron, my condolences to you and your family. Thoughts and prayers are with all of you. I know that you guys are not supposed to interact during public comments, and a lot of what you're talking about today, a lot of us have spent a lot of time doing research and would hope that you would perhaps go back and look at some of the comments that have happened in the past, especially with the issues of ordinances. A ton of research has been done by a lot of private citizens because we truly are concerned about our township. I know that we've thrown a lot at you guys. There have been hours and hours and hours spent. And as we mentioned in the last board meeting, there are some PC members that weren't even aware of general ordinances, and there are some of impact of general ordinances on what you're going to discuss today. I've saved recordings of all, so if you guys don't have them, I'm happy to pass those along. We have shown you, and this has been going on for a while, the improper split for the one parcel that is part of the old Morrison farm. Cheryl, you weren't at the last meeting, and I'll hand you a copy of the survey as a reminder, but it does not cover the 1 to 4. And we've had some conversations with PC and board members, and it really cannot be undone. And I think that's something you all should be looking at. As I always say, I want to thank you guys for your time. Hopefully you guys can work together today to figure out where we're heading. There's been some communication in the past about this moratorium and why it's in place. And I went back through several meetings, and this moratorium has been in discussion since last year. That was definitely prior to any thought of a Baggs Road site condo. Cheryl, you weren't at the last meeting, but I was appalled to see your answer to the developer. Starting on page 41 of the packet, of the board packet, I truly feel that Cheryl crossed the line in calling out private citizens. And as I said last time, I think something should be done about this. I think you crossed the line. I don't know if it's legal. I think there's an attorney online today for the township, but that should be looked into. John Roth was at the meeting and we spoke with him after and sent some information to him about it as well. The developer has not attended any board meeting or PC meeting since the initial March meeting, and he wasn't even there. It was his father. Even after Cheryl suggested it, I really expected him to be at the PC meeting and the board meeting. The moratorium is in place from what I have followed due to the mess of the ordinances and the master plan. And Cheryl knows that, as did Bob Hall. Bob Hall and the attorney had suggested again since last year, well before the site condo, that there be a moratorium just to help this township get their house in order. The paragraph about us is ridiculous. We have never mocked the zoning administrator. I know you've called me a liar in the past. I take great deal of, I don't even know the word to say. I am beyond reproach in my business. And I feel that that is borderline slander that you have taken about saying that I am a liar. We are questioning and researching the handling of the site condo application and the land split, which again, I mentioned is illegal. I, for one, did not lobby for 3 of the board members for this moratorium. I have simply been here since I found out about the site condo, questioning the split and the ordinances to ensure that what happens is in accordance to what our township has in place in ordinances and the master plan. I am not against development. There is a recording from on the news of Cheryl saying that we think that developers are evil. None of us have ever said that, ever. I'm very surprised that members of the Planning Commission and perhaps even the zoning administrator, like I said, don't have copies of general ordinances that have a direct impact on this land split and the site condos. I have not made an outrageous claim of harm on myself. That is another inaccuracy. And as far as technical expertise, the group of us that have been pointing out issues and concerns, as I've mentioned, have spent hours of research looking at what you all have put out there as far as ordinances. So if there's any outrageous claim of harm and we don't have technical expertise, it's because our ordinances are in such disarray. I guess since I've lived in Whitewater Township less than 20 years, I don't have the right to voice my concerns about development of our rural community, according to what Cheryl sent to the developer. The developer doesn't even live here. He may be a taxpayer, but I don't believe he has any plans on living here. He is going to develop and then go somewhere else. We have hopes and dreams as well of maintaining our rural community. I feel that in the letter that was sent to the developer, you are more concerned, Cheryl, about the developer that doesn't live here and probably never will than those of us that have been residents and will continue to be residents. We are not going anywhere. As another comment for today, I feel that if you all work together in looking at where we're at and go back to the basics and take the comments that we've made, take the time to go through this research that we've done, we've helped a lot in getting things together and the flow chart and all of that. And I think that would answer a lot of the questions that have stemmed or created this moratorium. And I too would like to see the moratorium be lifted as soon as possible so that we can continue developing our township in the right way according to our rural character. Thank you for your time.
Connie Highmore, Bags Road. Why are we here today? First of all, I'm glad to, I was going to say see, but I'm glad to know that the PC and the board are working together to look at the issues regarding the moratorium. This moratorium was put into effect on July 12th of this year. It's been 71 days, and yet no goals have been established as to what has to be done to lift the moratorium. There are 102 days left. Does the master plan need to be updated and complete? We have general ordinances that have been amended and never updated. Do the general ordinances, which are in shambles, need to be reviewed, reorganized, and reissued? Do all zoning ordinances need to be updated and reissued, or just some? The moratorium deals with site plan reviews, special use permits, PUDs, site condominiums, plat approvals, and condominium conversions. All of these need to be in order before we can move forward. These problems with our general and zoning ordinances did not happen overnight. They cannot be corrected overnight. Please do not rush this process and get the moratorium lifted and then have to go back and amend them again after the master plan is updated. I implore you to make a plan, implement it, and tackle this together with the end goal of making this process a success. The future of this community depends on the hard work of all individuals, not just one or two. This has got to be a team effort. We are here today without the planner. Why? Why schedule a meeting without the professional that has all the knowledge needed to navigate this dilemma? In Article 25, site plan review, is Article 25, site plan review and special use going to be as separate important articles? I see in today's agenda on page 44, the findings of fact, the statement that special land use standards should be clearly distinguished from site plan review standards, further exemplifying the need to separate them. There has been much discussion on the moratorium, and yet there are no goals set forth going forward to determine what has to happen. We should not leave here today without clearly defined tasks that must be completed before the moratorium can be lifted. I made part of this statement at the last board meeting, but Cheryl wasn't here, so I'm going to repeat this paragraph. In the agenda for that meeting on page 43, there was an email communication from an elected township official to a developer. I want to go on record again to state that I am disgusted and offended that Clerk Goss called out 3 private citizens by name in her correspondence. How is it possible that an elected clerk has the audacity to respond in such a way to a developer? Is she speaking for the township board? Were her statements legal? What is going to be done to repair the damage done by Clerk Goss? Who is going to hold her accountable for the irreparable damage she has done? Does she have the right, the legal right, to respond to that email? Vicki Beam, Karen Boyd, and I are not board members that she regularly disrespects. We are private citizens. We are not able to defend ourselves against her misinformation and allegations. We are American citizens whose reputation and honor have been damaged by an elected official. Her response to the developer injured 3 private citizens, attacked the professional reputation of the board, and jeopardized the township's relationship with the developer. I want something done. The subject of this horrendous attack from Clerk Goss is far from over. We, the people, will not be crucified by Clerk Goss. Thank you.
Anyone else here in Township Hall? And I don't see any hands raised in Zoom land, so I guess we will continue on. First item, let me adjust the volume on my phone, is review details of 7/12/2022 moratorium site plan review. Mr. Patterson is supposed to be online this morning. I do not see him. So I guess we'll just begin. Any thoughts or comments about moratorium?
Do we call the attorney up and see where he is?
We could do that. Hi, Chris. How you doing? Are you on the meeting yet? Okay, sounds good. Thank you. Yep. Good. Bye. He was adjusting his schedule because typically public comment runs about 35, 40 minutes. So it'll be 3 minutes. So in that time, I'd like to address some of the comments that we've heard both from the Planning Commission and the public about scope of this moratorium. And so as it was drafted, the moratorium does kind of call out site plan reviews, site condominiums, planned unit developments, special use permits, plat approvals, and condominium conversions. So those are the items that really need to be addressed as we hear both public and what we hear from the development side. And so I think site plan review has kind of been forwarded to the board as of August 6th, which from the Planning Commission, and it was on our last agenda. And because of the amount of detail in the particular section of site plan review, it warranted a special meeting. And so here we are. I too thought that there would be a division in site plan review between site plan review and special use permits. I thought that was a discussion at the PC level. And maybe we can hear, I think maybe we have the Planning Commission members, both Al Keaton and Kim Mangus, unmute. So as we have questions throughout today, they are able to respond. Is that appropriate board consensus, or does the board wish to do something different?
Well, before that happens, the list of things to be addressed in the motion, that is not a scope of the moratorium. The scope of the moratorium would be a listing of what needs to happen with those things. Okay, so you can't just list those things. Oh, we're going to address these. How are you going to address them? What needs to happen with site plan review? What needs to, what article, what specific articles and or sections of the zoning ordinance need to be addressed in order to handle site plan review? That is what is lacking. There is no specificity whatsoever to the moratorium that tells us what exactly we have to do, what sections of the zoning ordinance, what articles need to be addressed. It's just a blanket site plan review, special use permit. I want to see what needs to be addressed. We've got people out in the public claiming something needs to be done with the master plan. what specifically needs to be done in the master plan. What does get your house in order mean? That's vague. What does ordinances are in shambles mean? That's too vague. What ordinances? What is in shambles about them? What are those items that have to be addressed with specificity? Because you're talking about something that's not going to be done by January 1st. So what, no one knows what exactly has to be done. What has to be done? That needs to be in the record, what exactly has to be done. Because right now it's just, you could drag it on for who knows how long. Meanwhile, the constitutional rights and due process, constitutional property rights and due process rights of people in the community. And it's irrelevant whether the developer lives here or is going to live here. The developer is a property owner here. We represent him too, as we do all property owners and residents. So he needs to know exactly what has to be done. Mr. Parker with the letter on the High Point Golf Course thing. Robert Parker, the new letter asking about this moratorium that was put in place. No one knows, no one has any concept of what has to be done to get this moratorium lifted, as in an itemized list of what exactly needs to be done. We need to see that. Because you've got a vague list, but no detail as to how those things are going to be accomplished. Who's going to accomplish them? Is it a board agenda item? Is it a planning commission agenda item? The right hand doesn't know what the left hand is doing. It's chaos. Zoning should not be in chaos. There's people who have projects underway. If this moratorium had been put in place earlier, we wouldn't have the Williamsburg Animal Hospital open yet for business. Those people would be being held up. No one knows what's going on, what has to be done. This huge blanket moratorium has been put in place, affecting all major development in the township. This is the first I've heard of that there's something wrong with a split. Let's get, the splits are handled. Please stop laughing. Okay, it may have been mentioned, okay, but this is where I've heard more about it. What's being done about that? Let's have a statement from the zoning administrator and the assessor. Let's have them comment on that. Why, I'm sure that they feel that it was done correctly. If they're alleging that something was done incorrectly, let's get it out on the table. What exactly was done incorrectly? Let's get this issue solved. Okay, you're not gonna get anything done until you start getting very specific about what supposedly needs to happen. And I will further state, as far as my letter to my email to Mr. Van Solkema was entirely appropriate. I did not vote for this moratorium. It's definitely should not have been put in place. And we've had another site condominium project in this township that was approved years ago and didn't get held up with this kind of process. And the other thing that has come to my attention recently is that we've got someone out here, Vicky Beam specifically, I'm going to call it right out, playing the politics of personal gain. Vicky Beam owns a lot of property. She has subdivided her property. Her lot sizes are larger. I got all this information. I know all the lots she has, what size they are, and she is a developer. So she wants to distinguish between, she's a developer who lives here, and other people are developers that don't live here.
I am not a
Okay.
developer. I'm not going to sit here and listen to that.
I'm sorry,
I'm not a developer.
and it's
And
not,
as far
it's
as
not
the
your
split,
turn to comment,
here's the
Vicky.
split.
Are you gonna get the
Please sit
meeting in
down.
order?
Here's
Please
the
sit
split
down.
Right there. It's more than 4-1, and it was brought up in the planning
And
commission
you're
meeting,
wrong, Cheryl. You're out of
and Bob
line.
mentioned it.
I am
She
not
is-
out of line.
She is allowed to divide her property.
And-
That does not mean
Oh,
it is a
well,
subdivision.
Excuse me, let me finish my comments, okay? So what's going on here is that Vicky Beam has subdivided a whole bunch of property over there. And her lots are larger than 1 acre lots. And what I see happening here, she'll deny this, of course, but she doesn't want to see the property to the south of her developed into 1 acre lots, because that's going to make her lots are not going to be as desirable. Most people don't want larger lots, okay? And I feel
How can we
that,
allow her to put words in people's mouth? This is totally uncalled for.
She hangs herself.
can we please have you call the meeting to order? And public comment is over. And so these outbursts are uncalled for. And so Vicky Beam is down here. She bought all the property to the north and the west of her, but the property to the south of her is not under her control. And she's been down here for months now. Mr. Van Solkema doesn't need my email to go through the minutes and see all the times that Vicky Beam, Connie Highmore, and Karen Boyd have spoken out against the Baggs Road condo, put up signs, sent out emails, sent out letters to people in the township, trying to get them to donate money for a lawsuit. So people have come forward to me with, what some of these letters have said. And so what we've got is someone who clearly is a developer in their own right, because they have subdivided property, and they don't want to see the property to the south of them developed into smaller lot sizes, because in their opinion, that doesn't fit the rural character of the township. So even though rural character is not defined anywhere and would likely mean something different to everyone who was asked. So I will call out what I see as conflicts and people who have agendas and who have been lobbying this board for their agenda. Meanwhile, they stand to gain. So I will continue to make those comments. But back to the issue at hand, there is no list of exactly what has to happen. Are we going to be told at this meeting today or at another meeting, oh, I guess we need to put larger minimum lot sizes on property on the north side of the township, because Vicky Beam's properties are all larger than 1 acre, and she doesn't want to see properties developed into 1 acre lots. So, is that coming down the pike? What are these master plan changes that supposedly need to be made? What are the zoning ordinance changes other than Article 25 that supposedly need to be made? There's a lot of vague comments, and there's no specificity coming back from this board about exactly what needs to be done. So when will this moratorium ever be lifted? Because we don't know. We have nothing to measure the process of getting the house in order. We have nothing to measure that process by, because we have no list of what exactly needs to be done and changed and why it needs to be changed. Those are my comments.
Any other comments?
Well, normally you have all your resources at the table, so we're kind of lacking one or two, but I think we need to make an outline, go down and have a checklist.
What kind of checklist?
Well, basically, we do A, B, C, D, and then we continue on. Whatever we need to do to fix what's broken and make it so that everybody understands, common terminology included, of where we're at and where we're going.
So just out of curiosity, Bob Hall has indicated for months, maybe even almost a year now, that there were missing components in the master plan. Let's just take the master plan to start with. Is there ambiguity in what he has been repeatedly saying? Or
Well, you got the master plan, you got ordinances, zoning and general.
well, I think most of the comments I recall from Bob are about master plan. And then the other comments that I've heard revolve around separating Article 25 into a couple of different sections. One being just site plan review, and then the second being a higher level of scrutiny, shall I say, into special use permit reviews. So in special use permits, my understanding, the site plan review is probably the least intrusive that the zoning administrator can do and or the planning commission can be involved with. And really, if the requirements of the site plan review are noted on the plan set, I think the zoning administrator, by his or her own appointments, can approve a site plan. Special use, I think, requires that the planning commission be involved. And again, if all of the requirements of a special use are met, then I think that plan can be approved. So what I've been hearing is that the site plan review actually has no requirements. And this board has talked about that. What I recall is that site plan review, Article 25, kind of indicates if you have garbage bins, then you need to show them on the plan. You need to shade them from the view of the public. If you have sidewalks, they need to be shown on the plan. Well, if you have sidewalks is not a requirement. So I felt that's what the Planning Commission had been working on since November or thereabouts of last year. And when Kim first came to me and said, I don't know, this is probably about June, that she thought article amendments 83, 84, and 85 might be ready for the board to review, we saved a place for her. When they weren't quite Planning Commission approved, then it was postponed until the September meeting. And so that's kind of where we're at. And so the moratorium allows us to have a clear delineation between old and new requirements. I didn't expect the moratorium to last this long, quite frankly. But yet here we are. And so we talk about the ordinances being in shambles and chaos. We just approved a land use permit to build a building showing a non-motorized trail as the driveway to a private building. So if we need a further example of chaos and shambles, we need to look no further than all of our ordinances, including our general ordinances. And so that's kind of where I'm at.
So in other words, all ordinances need to be reviewed before the moratorium can be lifted.
Those are not the items listed in the motion, Cheryl.
Right, right.
You're welcome to be difficult. We all expect that.
Sure, yeah.
Yeah, we do.
Well, I swore an oath, remember? I swore an oath to the US and Michigan constitutions to support those documents. And they call out property rights. And I have always been an advocate for property rights. And when I see people's property rights being violated, I'm going to speak out on that because I have a duty to do that. So while you want to stand here and say that, you know, we had a planner back in March, we had a planner. And that was supposed to get the master plan up to date. And he brought a demographics section to the planning commission, and they didn't want they didn't really want it called out in the master plan that we're 95% white here. Okay. And I can see why, because that shows that maybe you've got some racist policies in the township, discriminatory policies in the township, in your land use. And I know that we do, but we're not here to talk about that today. But as far as the master plan, Kim Mangus was told by Lindsay Wolf, the prior zoning administrator, that there were elements of the master plan that did not meet the statute. And Kim Mangus did nothing about that. Then Bob Hall reiterated that. But those things don't need to be fixed in order for development to go forward in the township. That's a red herring. Okay, what is it that absolutely needs to be? Do we have to have site plan review standards? Do we have to have special use permit standards? Do we have to have those in place? Then let's get those in place. But we have all this other fixing of ordinances and, you know, this ordinance in shambles with no list of what ordinance they're talking about, ordinance or ordinances. That doesn't all need to be done. The township has been functioning. You know, ordinances do need to be updated from time to time when the law changes and stuff like that. And we can consult our township attorney about that. But as far as revising the master plan, and by the way, this is not a complete rewrite of the master plan. It's supposed to be an update to bring it into compliance with the law. That doesn't need to be done before a moratorium is listed. Every general ordinance doesn't need to be gone through before a moratorium is listed. I'm looking for exactly what needs, I'm looking for specificity, what needs to happen to get this moratorium lifted so that we aren't getting sued by every developer coming into the township. We haven't been sued by the Baggs Road Partners yet. We have a letter from an attorney who, with the High Point Golf Course thing, that they would like to move forward. So, and they've asked for some kind of waiver. Okay, so that becomes problematical because you set a precedent with a waiver, then you're going to have to give it to everybody else who fits into that same category. So Is it that we just need to get Article 25 so that the planning commission can properly review the site plan for the Bags Road development? Once again, I'm not hearing any specificity about what's broken that needs to be fixed. And when it is fixed, it will allow the moratorium to be lifted. There can't be that much that needs to be done. What is it? Exactly what is it? Because we can't go forward to fix anything until we actually know what we need to fix with specificity. And the motion is not helpful. The motion is vague. The motion should not have passed. However, it did. And now we're dealing with this, and we're going to just get more letters from attorneys, and we're probably going to get sued by the Bags Road partners. So we need to find some, what's the plan here? What is the plan?
Okay,
Let's get a plan.
so I don't disagree with getting a plan.
No. I would
Disagreement
like,
here.
I would like to know, back on 2/2/2021, Cheryl, you said you were going to give us the first rough draft legal manuscript of the township ordinances. General and zoning were recently provided by Municode. In the coming days, I will distribute that manuscript and other information provided with it to the township zoning administrator, planning commission, and fire chief for their review.
Everybody has it.
Okay.
The Municode transcript has, all the board members have it. If someone didn't get it, like Don wasn't on the board, we'll send it to Don.
Thank you.
Goss will send Municode transcript to Don Glenn. And so I'm still waiting to hear the details of the plan. And all of these people who are coming into the township and have a development that is being stopped under the moratorium have a right to know what the plan is as well.
So to develop a plan, I guess we would need to review the next amendments, 83 and 84, huh?
I didn't vote for the moratorium. Okay, so
But how would you
the people who
develop,
voted for the moratorium should tell us what the plan is.
how would you go about developing a plan, being you have all these ideas? How would you go about developing a plan? Would you read the ordinance and then?
Well, first of all, I would like to know
Have you
what
read-
is wrong.
Have you read the amendments?
I haven't read all of them. No, I haven't. I didn't have time to read them all.
Okay, so
Okay,
they've been
for this
coming to
hastily
us.
called meeting.
They have been coming to us since June.
They don't come to me.
They've been in our board packets. I'm
Okay, well,
pretty
we haven't
sure.
taken them up.
I
They
see.
haven't been taken up.
Okay,
Okay,
so
so.
you don't
well,
read
First,
board packets
before we have a
until
plan-
they're actually taken up? Is
before
that-
we have a
is that the
plan,
statement?
we need to know
Can you
what,
answer my question?
what is broken. What is
I
broken?
see.
Why was the moratorium put in place? What needs to be fixed?
I see what's broken.
Well, your comments are not
Well,
appreciated,
here's an
okay?
idea.
What's
I'll show you
broken?
one that's broken.
Why did the three of you vote for the moratorium? What's broken?
Here's a.
Let's
Can you
get the
tell
list
us-
going.
Can you tell us a single requirement in the site plan review? A single one requirement that's called out by site plan review.
So are you inferring that we don't have site plan review requirements and that's one of the reasons the moratorium is in place?
I'm just asking if you can identify one.
I haven't reviewed, looked at the ordinance for site plan review requirements.
Okay.
Is this one of the things that's wrong? We don't have site plan review requirements, then that should be the top of the list, shouldn't it?
Is it listed in the motion? Is site plan review listed in the motion? Yes or no?
But what about
Yes or no?
site plan review needs to be fixed?
I-
What about site plan review needs to be addressed? That's what I'm trying. Heidi agreed that there needs to be an outline and a checklist. What about site plan review? Is it, I mean, you're the three who voted for the moratorium. I didn't vote for it. So I
And here
didn't
we
think
are
it was
to
needed.
discuss,
So
and you
what,
didn't read.
what needs to be
Okay.
fixed about site plan review? What specifically is the issue with site plan review?
Well, if
We're going out of
everybody
order, but-
here hasn't read the articles, I don't know
Why are we here?
why we are here, nor why that member seems to monopolize.
You know, Cheryl, just the amount of time I've spent just going over these two ordinances. I have a question here. So you get to have 2.5 acres for horses and livestock, chickens and rabbits, but dogs get a whopping 10 acres. Why? Dogs make noise, horses make noise, cows make noise.
So
Why?
I think that at least where I'm at is to develop a plan for removing the moratorium.
And I'd like to hear from the attorney. It was, all these
Okay.
people made these suggestions, yet the resources aren't here to,
Okay, so I hear we need to make a plan. I think that's board consensus. And so the way to make the plan is to review those items listed in the motion for the moratorium. They're in this packet, so we can easily do that. And I don't have a problem hearing from the attorney, right? No problem at all. He may have other recommendations. So I think we're done discussing the moratorium. We're going to make a plan on how to remove it. Is that the
Well,
result of
if
that
Chris,
discussion? That's what I heard.
if,
That's what I heard.
I'm good with that.
Okay. And
if,
so,
if Chris Patterson is on Zoom, I'd like to hear from him. He recommended this moratorium at one time. What is his understanding of what needs to be addressed in ordinances? What is his understanding of what needs to be addressed to get the moratorium, to address the moratorium
Sure.
and fix those issues, which we haven't heard exactly what they are yet? Let's hear from Chris Patterson.
so I think that's probably the next step before we move on to actually ordinance review. Is that good with the board?
Yeah, I'd like to hear from Mr. Patterson as well.
Chris, are you available for comment?
Good morning, everybody. And I apologize for being late too. It got stuck on my calendar at 9:30, not 9. So when Ron called, I didn't realize I was late until I got on and you were meeting. So I apologize. So a couple comments in my involvement, which actually I think maybe even started last fall. We had sort of corresponded, I believe it was with the zoning, also with the planning zoning administrator, but essentially looking at Article 25 and your special use and your site plan process. And just like painting in broad strokes, if you look at current Article 25 that is on your website, you'll see that 25 starts with the site plan review process, and then it kind of throws in the special use permit process starting at 25-21. But what was interesting, and I think what was raised by, and it may have been when you started your master plan process, or it may have been raised by Bob, the zoning administrator, independently, was this idea of, look, when someone files an application, it's a little bit conflated as to how the site plan standards and the special use permit standards work together. And just for a little bit of background basics on a zoning request, if someone does file for a special land use, in most instances, they also have to go through the site plan review process. But they're two separate decisions, and they're also they're subject to two separate standards. We consider sort of the general special land use standards to be discretionary standards. There typically are some discretionary standards listed for the special use permit process that would allow you to decide if that project or that use that's been denoted as a special use is, harmonious with adjacent properties. Is it compatible with the land area, et cetera? And those are all standards discretionary by the Planning Commission. They hold a public hearing, they do a fact-finding analysis to determine if those standards are met. And that section in 20, when you look at 25, you will find that it was a little conflated as to how someone would apply for an application and go through that process. So that was raised, I believe, last fall. And that ultimately was our recommendation through, I think, Bob or the supervisor, I'd have to look, but to, look at doing a zoning ordinance amendment. And I know at the time, the Planning Commission was extremely involved in also working on regulations that we were subject to litigation about with respect to medical and recreational marijuana. So I know that they were pretty busy with that. And there were some concerns in talking with Bob and exactly how we would get that on the agenda to get that sort of work through the process as well. But that was initially when our office got involved, and it was our recommendation. And I think really the township was interested in doing it on their own without our thoughts. But once it had been raised to us about 25, we did agree that it would make sense to look at 25 and we could go in and further clarify the distinction between the site plan and the special land use standards. I think that's also important for a second reason, because the site plan review process can be effectuated on projects outside of something that's not a special use. If you look at the beginning of 25, you'll see those projects and uses that are subject to site plan review, and they may not be subject to a special land use review. And so it's a non-discretionary process where we go through, we look at a site plan and we verify that, as I think Ron was providing examples, if you have a sidewalk, that the sidewalk's provided. If you have a fence, the fence is provided. Where are the setbacks at? Where are adjacent properties, et cetera? Typically, in most zoning ordinances, they're actually in separate articles for that exact reason, so that someone who clearly is doing a special land use process would go to one article. When you're doing a site plan process, you would go to another. And so there was a project last fall. It kind of raised this issue, and that's when the zoning ordinance amendment process was kicked off. In your packet, so not related to what's in your current zoning ordinance, but what is in the proposed amendments from the Planning Commission, is zoning ordinance amendment related to Article 25 that we have provided our feedback to the Planning Commission on, and I understand that they have subsequently met on it. And in looking at the notations, you will see some of the items that were recommended from our office, but we otherwise did review the work of the Planning Commission, and we are in agreement with respect to the recommendations in specifically Article 25 and the specific standards being added for the special land use review process. We worked with through Bob, if I remember correctly, in sort of ensuring that the standards that were being set forth were creating that distinction between special land use review and site plan review. I won't go into the particulars of what's in the packet. I think that the red line, there's clean copies as well, but I think the red line does a good job of showing you what was edited, as well as there's blue text that shows you some of our specific recommendations with respect to language. And then also there's some notes just explaining to you why certain items were added. And you'll specifically see, if you compare section 2521 to what you currently have in 2521, that ultimately is sort of the build out of the framework that was specifically raised last fall and what the Planning Commission did endeavor to work on and add. So I think that would address in part the special land use process, and certainly that portion of the amendments that are being proposed. So you still don't have to have a complete package of amendments to move this forward either. As the way that it's presented, if you look at the clean copies, the edits to Article 25 are presented in a separate clean copy and an amendment. So certainly that in itself can move forward. And then, for instance, I heard the comment related to sort of one of the substantive items for instance, dog kennels, and that's in the table, that's an edit. That can certainly be further reviewed and assessed by the township board without sort of holding up your ability to decide if 2521 has an appropriate process for your special land use review. As to the site plan process, site condominiums and condominium subdivisions, So I think back and I will give you the shorter history of this, but I would say as far back as maybe 2011 or 12, we've been involved with the township related to condominium approvals and the potential process that used to be at least less than clear in the township ordinances. And that actually resulted in some litigation back in, I want to say it was 2013 or 14 that we ultimately resolved related to a condominium approval. We ended up getting dragged in by the lenders who figured out that the condominium project itself was not, according to the township, approved, but otherwise had been reflected as being approved. And they had sued us due to sort of the financing and the lending that they had leveraged on that piece of property. And after that was resolved, we've actually issued several opinions to the township related to what I believe used to be at that time ordinance 25 and 28, and exactly how condominium subdivisions and the zoning ordinance work together. There was an amendment done to the zoning ordinance later on, I think within the last couple of years, really, maybe the last 2 years, to clarify specific provisions related to condominiums. But there has always been, there always used to be an ordinance that sort of existed under the prior Subdivision Control Act that kind of always conflated the standards of how these different division processes or development processes would work. And so that should be clarified to the extent that anybody thinks it's not. I don't know that that would hold up a moratorium on everything. I think you can certainly be pretty precise and narrow as to the concerns that you would provide in a moratorium. But the site condominiums, condominium subdivisions, and PUDs has continued to be a topic that's been discussed and analyzed in your zoning ordinance, as well as your police power ordinances that you have related to that. And then my only comment, and I'll take any questions, with respect to the actual motion that's proposed, again, I think you can certainly be precise as to what you specifically would want to have a moratorium on, like what specific applications or processing that you would subject the moratorium to. If you do, for instance, move forward with the special land use permit process, realize that most special land use permits also require a site plan review. Now, the Article 25 zoning ordinance amendments, that includes amendments to both your special land use and your site plan process, because you contain them within the same article. So if you're satisfied with them, those items could be removed from your motion. But if you would move forward with the special land use permit zoning amendment, and you think that that clarifies any issue with processing them, effectively, if you retain a moratorium on site plans, you're still going to sort of inhibit those developments from moving forward. Anything that would be a special land use probably is going to require site plan review. So you could consider that. I just want to make that clear, even if you do remove it. And then the second thing I would say, if you do move forward with a motion like this or one similar, I would recommend that you come back and support that motion with an ordinance. Moratoriums are typically supported by an ordinance, and it would go in two forms. You can have a police power ordinance enacted by the township board to get the process started. And then typically, more recently, due to a decision out of the Eastern District of Michigan, when a judge sort of decided that moratoriums themselves, as it relates to the zoning process, can further be followed up with an actual zoning moratorium ordinance, which, i.e., that means following the Michigan Zoning Enabling Act's process for enacting an ordinance. You would essentially enact that moratorium in a supplemental zoning ordinance as well. So if this is the direction that you want to go, I would recommend that you consider coming back with both of those ordinances. The one obviously has to come through the Planning Commission itself. They would recommend that zoning ordinance moratorium. There'd be a public hearing on it, just like any ordinance that's adopted under the MZEA. It'd come back to the board. And of course, you'd already have a police power moratorium in place, but then you'd have this supplemental zoning moratorium in place. In that ordinance, you could specifically specify a few things. One, the ordinance typically will assist you in identifying exactly why you're engaging in the moratorium. So what are your governmental interests for doing so? There's actually quite a bit of discussion sort of in the packet, I know, in the memo about that, also in the prior minutes. So those are items that would really can be sort of provided in there. And then in addition to that, you can specifically delineate, again, like what exactly you're placing the moratorium on. Is it for individuals who are applying for any developments? Is it for the 5 or 6 items that are listed? You know, exactly what does that look like? And then, of course, Also realize if you enact this, you always could provide for the ability to exclude items out of the moratorium as you get those ordinances in place. The ultimate idea behind a moratorium, of course, as has been adopted by the U.S. Supreme Court and sort of endorsed in sort of numerous cases over history, is the idea that you're really attempting to stop sort of disorderly development while you're putting together your zoning regulations. Because I think the Supreme Court recognizes that in a zoning process, once you issue a permit and they start substantial construction, those individuals have vested rights. And so the idea would be, instead of sort of dealing with the law of nonconformities, this moratorium allows you to put it in place and then allow for the preparation of regulatory ordinances through your zoning scheme that would stop sort of some type of development concern that you have that otherwise will be impacted by a future amendment. And then I'll take any questions, I guess, as it relates to other items. That's been our involvement in the process.
Heidi, any questions?
I think I just have one right now. On 25.21M, amendment of special use permits. How do you define minor and major?
I think that probably goes to Kim or Al. Is that right? Or is that an
Well,
attorney
I kind of wanted to
question?
know from the attorney because
Okay,
minor and major isn't in the list of definitions. So, you know, now we're leaving it up to the zoning administrator, what he feels is minor and major. Don't you think it should be defined a little more? But
If-
whatever.
So if I can comment on that, it actually is defined, and it's defined in a couple of ways. So I can point that out with respect to the provision. If you look at 25.221M, you will find that it is provided to be determined by the zoning administrator. So when you're looking at a section like that, you need to also consider Article 17. Article 17 also sets forth all the specific duties and the delegated authority of the zoning administrator. You'll find in that section the specific reference to the ability to administer the zoning ordinance with respect to any applications that are filed. And the definition section in the zoning ordinance also provides for a general standard of how you define terms that are not otherwise defined in the zoning ordinance. So you want to consider that as a backdrop when you then consider the phrase that follows the reference to the zoning administrator. And that ultimately is a standard that the zoning administrator applies to have no foreseeable effect beyond property receiving a special use permit, such as minor changes in the location of buildings, the alignment of utilities, and the alignment of interior roadways. And of course, anything not deemed a minor amendment is a major amendment. Now, there's still two additional processes that further sort of box this in. One item that further boxes it in is that if the zoning administrator were to take the position that something were a minor amendment that does not otherwise satisfy that standard, there's always an administrative appeal process to the zoning board of appeals to say, no, that's not what the zoning ordinance says. And of course, then the second process there is that the planning commission ultimately has authority as to major amendments. And so there's a little bit of cooperation between the zoning administrator and the planning commission, which you'll find in the second and the third paragraphs. There are some municipalities who go a step further and attempt to list factors for the minor amendment so that you know specifically what exactly is encompassed there. But when you look at those municipalities, you're going to find that the factors that they list are pretty comparable to the last sentence of the first paragraph. And if you look at that sentence, you'll further see where the scope is delineated as to a minor amendment so that it, again, like it shall not increase the size or height of a structure. You can't reduce the efficiency of some public facility, meaning impact road infrastructure or impact sidewalks or whatever was previously approved with respect to a special use permit. I think the idea typically, and we've had this happen quite often. So you go to site a building and let's say that because of, they haven't not yet unearthed to dig the foundation. They go to dig the foundation and they figure out that there's a reason that because of compaction or soil borings that they need to adjust 3 feet, but everything else otherwise stays the same. You know, that's the type of minor amendment that would align with this. Or they reference on their site plan, here's where overhead utilities are coming in. It's on the site plan, But then as the utility company comes in, after they sort of lash from the last pole, there's some maybe difference in 4 degrees of the way that they attach to the building because of some aperture or construction requirement on the exterior of the siding. Again, that builder wants to make sure that they conform to the plans that were approved by the township, but to go back through an entire special use permit process when otherwise the standards would be met, there's nothing effectively being impacted from the zoning ordinance perspective other than these minor changes. Those 2 sentences with sort of the rest of your backdrop in your zoning ordinance are designed to frame the scope of what a minor amendment is.
So with that thought in mind, I too had several questions revolving around definition where, and just to keep this very broad brush stroke, the proposed Article 25 says something. For example, major, minor. Wouldn't it be, should it be called out that see Article 17 for, further discretionary definitions, so on and so forth. I mean, if I was reading what Heidi had read, I would think, okay, well, what is the definition? And so I would go to, in my opinion, I would go to Article 3 where definitions are. Article 3 has no definition of major, minor, has no inkling to go to Article 17 for a definition. That seems that specific scenario is riddled throughout our ordinance. And that, to me, is what is chaotic or broken.
So 2 comments on that. I mean, one, certainly, township board, it's your policy decision as to what you want the ordinance to say. So if that's how you want to format the ordinance, that's certainly your decision. There's 2 reasons why you will not see many ordinances with that type of system, and it's twofold. One, the zoning ordinance is not designed for any specific article to serve as its own. So when you look at a zoning ordinance, you always got to read it in its entire context. So any reader, anybody applying for something should understand that you can't read Article 25 to know what all the requirements may be for Article 25. And I don't know who designed, I suppose, the original set of zoning ordinances that were done in the 1920s under the Hoover administration to set up that framework, but that is a typical process. When you go look at the zoning ordinance, you know that, like you pointed out, Ron, that you would look at, I'm going to 25, but I'm also going to resort to the definition section. There's also going to be a general standard section. There's also then a section that provides for specific special use standards. So the reader understands that you have to work through the various sections of the zoning ordinance to make that work. Now, in some of the new zoning ordinances that we've seen done, they use sort of the technology in a PDF and they hyperlink that stuff. So I've seen sort of more recent zoning ordinances use a process that is, I think, more user-friendly for township residents or people who are applying, probably the township zoning administrator himself as well, or herself, when you're applying it, which is you could go to 25, and then if there is a definition, they provide sort of what we call bookmarks in PDFs, and it literally takes you up to, the definition section. You can read it there, and then you can go back through a table of contents to get back to 25. So you could certainly design it that way. I don't have any objection to that, but I think that's partially why no single article has all of the references to the rest of the zoning ordinance. There's 2 other items that are generally reasons why. One, some think from a drafting intent that if you were to reference, for instance, Article 17 in 2521 M, but then maybe not reference it in another section of the zoning ordinance, even though it applies, then you run the concern that someone would say, well, if you knew to reference it in 2521 M, why now are you saying that it applies, let's say, in 2521 K, but didn't cite it there? So there's sort of a drafter's intent issue, which is why sometimes that's not done. Certainly that could be fixed, though, by reading all the provisions and making sure that all references cross-reference any other relevant section. So I'm not saying there's not a solution there. The last one is really kind of a practical one. which is that, your zoning amendment is a working document. You're always making changes to it. And sometimes what you run into is if you amend a specific section, like 2521M references 1713, when you make that amendment, we can see it become typographical errors in the future when we go back and look at those sections. Like 1713 no longer says what you think it does. Like it does exist there, but somebody amended it. They didn't realize that the reference should have been changed because they weren't involved in the prior amendment. And so you're just kind of, it makes your amendments require a lot more time, and it's not quite as sort of cost effective from that standpoint, because someone's going back doing all of these cross-reference checks every time you change some section, or if you're trying to add a new article, or if you're trying to add sections. Now, like in one of these, you'll see an example where they reserved a section for marijuana. That's certainly a good idea if you're going to start doing cross references, because now if that use ever comes up in the future, you're not going to end up shifting down those sections and throwing off a whole set of cross references. And know that those cross references, if you put them throughout the whole zoning ordinance, when you go to do the amendment, you're talking about republishing all of those sections in whole. So the whole new ordinance you publish could be expansive. Your publication costs all go up, which everybody who's involved in publication knows that that's one of the most expensive parts of this process, is getting the publication of those ordinances. So those are, a couple of the main reasons why you don't see it regularly done, but there are people doing it with technology and bookmarks and documents that have a little bit more technological ability to go back and forth.
Gotcha. So taking the opposite approach to that then, and kind of reflecting on something you said just moments ago, any developer or private citizen who contemplates some type of improvement upon their land should read and understand the entire ordinance, not just the specific district that they might be in, for example.
Yeah, that is actually a perfect example. Your example is an apt one because, for instance, if you're in the R1 district and you're applying to build a single family dwelling, you will not find all of the provisions relevant to what you have to satisfy under the zoning ordinance in Article 6. You would want to look at Article 12, right? Building size, lot size. You'd want to look at sanitation requirements. You'd want to look at administration, right? Like what's the zoning, do I just get a zoning compliance permit? You'd have to look at Article 25. Is my use excluded from the site plan, et cetera. I think for the typical resident, it's much more complex to work through a zoning ordinance on your own. I'll certainly grant you that. For a developer, I think that they're more akin to this sort of setup. So it's more of a learning curve for the resident to say, look, like I'm in the R1 district. And in part, I think that's why a lot of your residents will reach out to your zoning and planning. They'll reach out to your zoning administrator and say, hey, this is what I'm trying to do. A lot of times you get calls about some of the simple stuff. I want to build an accessory structure and you have a 183-page ordinance. Like, where do I start? What do I do? Right. And oftentimes that's where that first touch point with the township gives them the direction to say, look, if it's an accessory structure permitted by right, it doesn't exceed 2,500 square feet. We just need a zoning compliance permit. You can get that application from my office, whatever. There's a $50 fee and here's how the process moves forward. As to any specific details, you're going to want to look at the building and land requirements, et cetera.
Hey, Chris, this is Don Glenn. I want to go back to earlier in the statement and appreciate your comments. Very helpful. Being one of the newer board members, there's a lot of historical perspective that a lot of people around the table seem to have that still bringing myself up to speed on. I view a opinion that Article 25, site plan review and special land uses, I guess I strongly opinion based on my commercial activity in the past and looking at other townships in Michigan, there seems to be a delineation and more common that those articles are separate, although, you know, intertwined, but from a clarity standpoint, it seems to be, at least in my mind, that it would help our developers and our internal personnel, that if those sections were separated rather than embedded together, because I do think that once, to your point, you're trying to build a roadmap here in going from one part to another. And I think there's some disconnect in that in going into some of the other articles. And I think those are some cleanups. But where do you opinion in regards to my comments that we may be better off in the long run splitting out site plan review, which does focus an awful lot on use by right, and then those things that the ZA and the PC can act on obviously fall with a pretty good dose of clarity. But then those areas that we see projects come that don't fall within those or need other conditions, is it better to then reference and go to, you know, Article 26 or 27 or whatever the number is that might be open, and create the special use land uses in itself by itself?
Yeah, I don't disagree. As I said, I think many municipalities do split them out. You obviously have Article 26 and 27 reserved. So conveniently for you, it's not going to reset the sections that are afterwards. I think that's helpful as well, because it's a pretty easy fix to sort of split those. I would say your only sort of maybe limitation is that obviously the board, having the planning commission's recommendation, can make those amendments here at the board level. You don't have to send it back, but given sort of probably the substantial kind of framework change that someone needs to go through and double check how that would look in its own article, probably the one thing that maybe would be a consideration for that is just timing. There's probably going to be certainly some additional time and meetings to sort of split those out. So, but for purposes of, like you said, giving an applicant a roadmap when they look at the table of contents, if you know that you're doing a special use, then certainly you would go to that section. The other benefit is that if you look at Article 25 and you look towards the end of it, the special land use section also has all of the specific standards for specific special land uses. So like back to Ron's comment, if you were to only look at the residential district and you were trying to do a special land use, you'd have to go to Article 25 and then scroll all the way towards the end to see if your special land use also has specific special land use standards. So it does make Article 25 related to site plans quite extensive. Most of the time they're much shorter, right? If they're only addressing site plans. So there's an added benefit of that for the reader as well, because it kind of, if you were looking for a special land use standard, you wouldn't scroll through Article 25 to the end, you'd get to 26 and it would literally be only for special land use. So certainly a warranted consideration for the board if they so choose to do that.
Thank you for that explanation.
Following up on that, my question would then go to the PC members here. Why that split wasn't pursued, because it was certainly talked about early on. Any thoughts? Kim, I see you unmuted.
Yes, Ron. We were asked to separate the standards. Quite honestly, it was never proposed to separate them into separate articles. So if at any point that was the board's intention or Bob's intention, that was not conveyed. It would be a fairly simple matter to separate the two items, specifically because of what Chris said. The next article is currently open. But I would put a caveat on that. Separating them with the standards that we have proposed to you for adoption would not be difficult. I would strongly encourage the board, given our current environment, to adopt our current amendment and then send us a request to separate them into separate articles, because like Chris said, it will have a ripple effect through the ordinance of references in maybe 10 other articles that will need to be adapted. Where it says, see Article 25.22, that has to be changed. And that is time consuming, not as much difficult as it is time consuming. If the standards that we have put forward for you are acceptable, accept the standards, and then let us readdress the logistics of dividing the two into separate articles. Just from a time perspective, it's going to take some time to put all of those things together.
Understood. Yes.
Also, it doesn't affect the functionality. It is functional in one article, although it may not be as convenient as necessary or as one would prefer. The amendment that we sent you is fully functional to address the issues that were brought before us.
I have questions for Chris Patterson. So, Chris, you said that you were looking at Article 25, the special use in the site plan process, and that it was conflated how site plan and special use standards are supposed to work together because they're really two separate things. And so is that, as far as this moratorium that I believe you recommended, is that Article 25 the only thing that needs to be addressed? Or as the motion said, plat approvals, site condominium, planned unit development, condominium conversions. So are you recommending that all of the planned unit development, part of the zoning ordinance, the site condominium, all of that also be changed in some fashion before this moratorium can be lifted?
So a few points on that. One, I had a conversation last fall about if there were concerns related to the special use permit process and the site plan review process, if they so wanted to engage in a moratorium, that they could endeavor to explore that. I don't know the extent to which, nor can I remember sitting here right now, conversations about a moratorium related to the other items that are listed. So I would defer to Bob and the Planning Commission chair to the extent that they're aware of other issues that need to be explored in that area. In my background, I'm not surprised by those items being in the motion because, like I said, in our firm's history of working with the township, you have consistently had questions in those areas. Whether it requires a moratorium or not, I don't know that answer. I've not been asked to sort of opine on it, nor have I looked at it. As to the specific question that was posed to me in the fall last year related to Article 25, I think part of the reason that the conversation went from trying to amend Article 25 to specify the special use permit process, and that the moratorium sort of came from that conversation, was again the fact that the Planning Commission was being put under pressure by litigation that was then pending against the township to get some extensive marijuana regulations put in place. And so I think the conversation bore out there as to, well, what do we do in the meantime if we know someone is attempting to apply and we're trying to fit all of this sort of stuff on the Planning Commission's plate with sometimes an inability to sort of schedule because of a lack of quorum or whatever. There was a lot of circumstances going on. I think that's how the conversation bore out about a moratorium.
And let me further supply maybe some background, Chris, and I think you stated this earlier, that really without a site plan review, use by right items don't move forward. Without a special use permit criteria, those uses don't move forward. And so if those two items can't move forward, then really that affects everything else that's listed in the motion. From site condominiums to, as Cheryl said, veterinarian clinics. If you can't agree on the standards, I'll say, for these reviews, then none of those things requiring those reviews can move forward. So that was the purpose, to include those in the moratorium motion. So,
So I guess I have another question. We have a proposed amendment to Article 25 here. And, you know, it's gonna take months and months to, for the planning commission to review. What's the exact wording again? Site condominium, planned unit development, plat approvals, and condominium conversions. Are we gonna be holding up development in this township for just whatever time it takes, a year and a half, 2 years, before all these things get ironed out? Everything will be at a standstill here. People who have property that they want to develop will be in limbo for all of that time. Is that the way we are going to do business with either businesses or residential property in this township? That we're gonna hold everything up until we get the perfect ordinance? I mean, obviously, this year's the 50th anniversary of zoning in Whitewater Township. And there's been, a lot of things that have happened here. And housing and, businesses and stuff like that. So, but now all of a sudden we can't do any of those things. Everything has to be put on hold until we get the perfect regulations in place. Is that what I'm to understand? I was addressing that to Chris. Is that what you're being told?
Bit beyond my scope, but what I would tell you though is I do agree with the PC chair that Article 25 as being presented provides you a fix for the site plan and special land use permit review process. And so like I said, we did review it. We're comfortable with the mechanics of what's provided in that article. And I think if that ultimately allows you, the board this morning, to move forward on that zoning amendment and put it in place to allow for that permit process to work out, then I think that, that's certainly our recommendation.
Thank you.
yes, Al.
Yes, I had a question for Chris. When it comes to the moratorium, do we have authority to look at a project that is entered into a permit? I'm going to use an example. Let's say the golf course. Do we have authority to say, okay, we'll look at that and approve or disapprove, but look at that and try to move that project forward? And can we do that without jeopardizing other projects that are pending? Can we single one out and say, okay, we want to move forward with this, move forward with it, and then pick another one and move forward without throwing the whole moratorium in the trash?
So you can get there, but I would get there by having a moratorium that provides for a standard as opposed to giving a specific waiver. So you could develop a moratorium and you could put in factors that would allow for applying for a waiver with standards of how much you would grant it. But I think the key is that you would want to have a standard set forth first. I don't think that then requires you to throw out your moratorium, and I don't think that necessarily weakens the moratorium, because someone who applies would have to sort of show that their project doesn't otherwise run into the concerns that the board has for having adopted the moratorium.
And to further that statement, I think that you've kind of already issued your thoughts that if we were to move forward on the Article 25 that we have in front of us, with whatever amendments the board agrees to, then that really resolves our site plan review issues for sure. And site plan reviews, those reviews related generally to use by right applications, could be removed from any moratorium that still exists. Is that,
Was that I thought that was a question you were asking of Chris.
So did I.
well, it was really.
Sorry, if you're asking me, I thought it was a statement without a question. I apologize. If it was directed towards me, I generally disagree with your statement. I think what you're saying is what I said, which is you can adopt the Article 25 amendment with the site plan special use permit amendments that will probably deal with most of the items it appears that you've identified in the moratorium motion. And so you would, if I understand what you said, you essentially would lift the moratorium and you would have Article 25 allow you to process those requests.
That's correct. That is what I said.
And that's still, Chris is done, and so that still allows, it still allows for, if the board so wishes, to still come back and create and eventually strip out the special use for special land uses into its own article number 26 or 27. I think we just referenced because those were open. But this doesn't preclude us from making that happen at a pace that is more to the actual process that it might take to do that. Would that be correct?
Correct.
So how are we doing with 25? And how are we doing with site plan review? This is a question for the board. I apologize. Do we have additional questions on 25? Either regarding site plan review or special use permits?
Let me just scroll down here real quick.
I mean, I've got lots of questions in the ordinance itself, right?
Mhm.
But this would be conceptual about how the zoning ordinance works. And so I'm not looking to do a deep dive
Yeah.
in the ordinance that's in our packet, although we can.
Now, conceptually, you know, I'm reading through the additions to special use, where I'm looking for the section here, what page it's on.
21.
It's already
I'm on
page
the
three.
red line.
Is that
I'm
on,
not on the-
is that,
21 is 25.10.
Yeah, but this should be special use, I think is under 2511 or 12.
yeah, that's what I'm looking for. Just see what my notes look like on that. Up. It's 20. I think it started at 20, page 23.
What section number are you looking for?
Yeah, was looking at the special use permit application, the special use is
2521?
2521A, which as it starts on page 23. I was just looking to see what my notes were on that, Cheryl. I
Right,
didn't have that
okay,
in my
yeah,
head,
I'm
so-
just asking what you're looking for.
Yeah, right. So I guess my comment is that there were just a couple minor things in there, but overall, my opinion was that I felt that there was some consistency there, that it was more in line what I was expecting to see. And I thought addressed it substantially better than what we currently have in our current Article 25, 25, 21, I believe what it's done. So I'm looking here. I'm not seeing anything of major objection that I saw that I felt was in there. So. I did have the same, and I did, and now, and you explained that, Mr. Patterson, I did have some of the same questions that Heidi Volmuth had regarding minor amendments and major. I guess I'm just used to seeing more definitive types of tables or numbers that, there's a delineation, there's a number, but again, your explanation to me was adequate for the time being. If we were going to split this out, I would probably want to have more conversation at a future date. Because I think a number being, i.e. The parking spaces changed by less than 10%, that putting a
quantitative.
Yeah, quantitative. Yeah. So that was my only thought on that. And, but absent having that today, I am satisfied with what I heard from Mr. Patterson in terms of how that would be handled up until that point, as we were able, because I still would be a strong proponent of splitting special use out into a separate article at some date, at some point in the near future. So, but its inclusion here, I could certainly feel comfortable with that.
And so because you brought up 2521, the issues I see here is that we've capped the ability for the township to bring in expert review at $2,500. I don't think that buys an awful lot of expert advice.
No, it doesn't.
And so while I understand the motive to potentially put a cap on it, yeah.
Ron, that's a
Yes.
minimum. That's a minimum additional fee. That is the minimum deposit that we would request.
Can I refer you to section 2521C?
Yes, the
That
applicant has
says-
paid a minimum additional fee of $2,500.
Well, please read that section, Kim, because it
Okay.
said paid a minimum additional fee of up to $2,500. So which is it? Minimum or up to?
Pick two words and delete them.
Um,
Understood.
I get it, but it's small inconsistencies
Understood.
in this document like that are several.
The specifics that you're getting to right now are genuinely what the PC needs to get back from the board, preferably,
Okay.
where it's these two words or this line is what we have an issue with. If you were to have sent 2521C back to us, I wouldn't know what words you were having issue with or what lines you were having issue with. So if, as you move forward, that specificity is the most efficient and most helpful for the PC. Thank you.
Sure. Okay, so conceptually, we're clear on how the site plan and the special use permit work within the ordinance. Is that a consensus?
I am.
Cheryl?
Yes.
Heidi?
Yes.
So the other topic, while Chris is on Zoom with us here, that I would like to, I guess, have some additional information is on condominiums. So when we read the state condominium ordinance, and I apologize, I have forgotten what the MCL number is. The word site condominium is rarely mentioned. And the statute really focuses in on what I seem to identify as a condominium association, right? This is where I buy a portion of a building. Generally, there's 6, 4, 6, 8, 10, 12 other people that have also purchased a section of this building. I own from the drywall in. We don't typically think about doing that same division with land. But that's really what a site condominium is. We create multiple users of the land that belong to one ownership. And so several places here in the document that we're going to review, it says see section 66 of the condominium statute. And really 66, all it says is, if I remember correctly, talks about deed requirements. You know, somebody's name's got to be spelled correctly and so on and so forth. There's actually no requirements, except that the information is correct. So my question here is, well, possibly rhetorical, but why don't we have a site condominium MCL? We certainly have a site condominium article, in our ordinance. Because there is a lot of talk about site condominiums right now. Is that the next item we want to look at or have the planning commission look at? First of all, Chris, this could be a question for you. Are site condominiums required in every zoning district?
So site condominiums are really a form of legal ownership, not necessarily a use. So that's why you don't really find site condominiums addressed specifically in the Condominium Act at any sort of extensive nature. It's sort of borne out from a land use perspective because site condominiums come with them the idea that even though it is a form of ownership, you're using it very similar to how you would do a land division. And so we sort of carved them out so that way setbacks and everything else is still applied within the individual unit that exists within a site condominium. So I think it's really, the term bears out some help in thinking about it from a zoning land use perspective, because then a condominium development, as you referenced it, more relates to maybe multi-density units, or where obviously the individual unit itself doesn't contain setbacks within it, right? So, I mean, that's really why the legal term is defined. Site condominiums, since they are a form of ownership, typically you don't end up with them being listed as a use, but you end up with either having a condominium article and or addressing them in your site plan review process. So if I want to have a real estate office in the commercial district, and I'm going to develop that building along with an insurance building and then the township hall, let's say, and I do it in a condominium process, those could be site condominiums, and I could do that in the commercial district. Each one of those site condominium uses would be subject to the different applicable commercial use regulations. And the same could be said for residential. So if you take a parcel and you turn it into a site condominium, the actual use is a single family dwelling, but then they're subject to the individual setbacks, minimum parcel size, etc. And I think that's somewhat consistent with what's trying to be done in the zoning ordinance. That's why they go through site plan review. That's also why you have a condominium article section.
And so if I was a developer and I had a 100-acre parcel of land, well, let's just go something smaller. Let's go something realistic. If I had a 40-acre parcel of land, I have the ability to split that land about 5 times through the Land Division Act as amended from 1967. Is that right?
Yeah, and if you're going to the sort of potential change in density for a site condominium, I don't know if that's where you're going, but
It is.
yeah.
Yep, it is. And so, you know, most landowners that have 40 acres don't know that they have the ability to put, I'll say 38 or 39 homes on their land. And for the past 50 years, as it's been pointed out, we've been surviving with this ordinance as it is. But as people's knowledge of ordinances increase, we now see that there is a development pressure that might have been protecting us all this time in the actual Land Division Act.
From that perspective, right, from the policy perspective of the level of density that you want in certain districts, then the answer to that is yes. From the zoning ordinance language, you obviously have minimum parcel sizes, setbacks that are related to any parcel in that district. And therefore, like that decision, that policy decision also has already been made in your zoning ordinance that you were prepared for a level of density consistent with the minimum parcel sizes set forth therein. The difference also, remember too, that doing a condominium association or a site condominium is not quite as one of the reasons that people still do land divisions, even though the Condominium Act's been around for some time, is that there is a much more extensive level of infrastructure development and cost by the developer who may want to do that, especially if you're doing maybe a non-site condominium project, more like a condominium development. You're typically building quite a bit of infrastructure that you're going to then prepare to the standards of the local municipalities, because you're going to have to then dedicate it to them if you're not going to maintain it as private, especially the roadways. So whereas if you're dividing property, like your 40-acre example, typically you're relying on driveways, maybe a shared driveway, or just road frontage across the front of all of them. So there are reasons that the condominium process still may not be preferred for people who want to divide their 40-acre parcel.
And I was merely trying to address an earlier point that we had gotten by 50 years with our particular ordinance, and it served us well. But as people's knowledge of zoning ordinance and specifically site condominiums in this case, they realize that they no longer are limited to 4 divisions of their 40-acre parcel for what, 10 to 15 years. And so we could literally take that 40-acre piece and put 38 houses on it. Yep, we have to make sure that everybody agrees to the road maintenance agreement. But really, as I read our existing site condominium ordinance, that's really the only thing the developer has to do is put a road in. We don't have to supply, or the developer doesn't have to supply utilities, just an easement for them to be installed. Now, as a developer, I may make the decision to go ahead and bury underground wires to make it easier for people to purchase lots in this site condominium. And then the other thought I had comes from the term parcel and the definition. You used parcel as in a potential description for site condominium, which really a site condominium forms lots, not parcels. Is that correct? Or is that incorrect?
Yeah, it's a little bit different than that because the Condominium Act actually prescribes for really two general items. You either have common elements or you have units. And really the site condominium, the parcel you're creating is a unit from the definitional standpoint under the Act. So if you look at your definitions, when you refer to condominium, condominium conversion, and site condominium, you're attempting to relate back to the fact that all requirements in the Condominium Act must be met. And your condominium design layout requirements do reference the site condominium as site condominium lots. But it's really a reference because we're referring to them as units is a little bit not the way that in sort of common parlance that we would think about their existence.
From an assessing point of view, does each condominium lot have their own tax ID number?
Well, 2 points there. One, with respect to zoning, of course, we're not getting into we're not sort of, the standards we have for there are not related to what's applied by the assessor. But my understanding with respect to the tax assessing process is that all of those units, of course, when you record the master deed, so you have basic requirements in the zoning ordinance. There is an entire act, the Condominium Act still has to be satisfied with respect to the recording, which has the master deed. The master deed has at least one sort of important aspect that is relevant to your question among a bunch of others, which is typically the sheets that come at the end of the master deed that will show what units must be built, what infrastructure must be or need be built. Those units then, when that master deed is recorded, the assessor will issue parcel numbers and they will get their own parcel ID. The common elements, and I don't know the mathematics used by the assessor, but the general common elements are then apportioned as part of, whatever rights that those units have. So, just to put a little bit of a cherry on top of that, there are two different types of units. So the assessor has some calculation where they're figuring out, okay, this unit has limited common elements. Like I may have a unit that shares a balcony with Ron, but then we may have general common elements where there's a pool that's shared by everybody at this meeting, right? So there's an assessment methodology that's done by your assessor to figure that out. And I pay for those portions of the privileges that I get in the condominium association, whether I'm a site condominium or not. I think if you're a site condominium complex, the general common elements go down, right? Because you have so much open space that you're including within the unit when you record the master deed. So it might be limited to things like utilities, roads, etc.
You touched on as a topic that I have heard requests for, and that's open space. I don't think, as I understand it, you cannot require a site condominium to have open space, can you?
Well, you'd have to go based on what is currently in your condominium article section. And you do have reference to referring back to your old subdivision ordinance that you have. It says apply those standards when applicable. I don't know the extent to which there's open space requirements in there, but a site condominium, remember, you currently have it set up so that they're subject to the minimum parcel and acreage size requirements of the land use district that they're going into. So it's no different than if I subdivide the 40 acres and I build 6 houses, right? I mean, the open space, although not meeting the definition of open space because that has a specific requirement, right? But that sort of idea of open space around my house is maintained by the parcel size upon which your zoning ordinance requires, which was a legislative decision of the township board.
Gotcha. So your use of open space was really just unused building envelope.
Yes, correct.
Gotcha. Any other questions for Chris? Do you want Chris to stay? Chris, what is your schedule
For what specifically? To be on this meeting?
today?
If you want to, if you want, I can be available, I guess, if you need to call me back at some point.
Well, I'm thinking that
There is agenda item number 3, consider legal support level for various boards and commissions and
Oh,
personnel.
yeah,
I don't know if I need to be a part of that conversation, but if not, I can certainly rejoin at a later time.
well, maybe what we should do board, do you think it would be valuable to have Chris in our discussion of amendments 83 and 84? Or do you think we should move item number 3 and discuss it right now?
Yes.
I would agree.
I would agree.
So let's skip over 2 and go to number 3. Is that what I understood?
Yes.
Yes.
Cheryl?
Yeah,
Okay.
that's what I said.
So, legal support level for various boards, commissions, personnel in their decision-making role. Obviously, without divulging a lot of information, potential litigation for marijuana concerns has moved from including the entire township to potentially a single member of the planning commission. Which could probably expand into any member of the planning commission or the board. So can you help us understand the process of maybe governmental immunity, who it extends to? Should the township have a policy regarding something like this?
Sure. Let me provide a little bit of backdrop so that everybody, I think I understand the impetus for this conversation because I was sort of involved maybe in the first parts of this. So obviously everybody's aware of the litigation related to North Point Farms versus the township. And that case was dismissed with prejudice in favor of the township. When that case was dismissed, there were representations made that there would also be a complaint. I don't know the extent to which it would be filed. I don't know the exact, sort of verb tense that was used, but we basically received a draft complaint related to a lawsuit that would be filed against the PC chair related to sort of similar allegations that were already being litigated in the township's case. And so what arises from that is if you have a elected or appointed official, or really to the extent if you go past that, or you think about staff, maybe a zoning administrator, although probably largely an official, how do you sort of provide legal representation for them? Are they defended by the township's legal counsel or not? And I think, just to answer Ron's questions pretty specifically, one, anytime that an officer or an employee has a lawsuit that is against them related to their capacity as part of the township, then your insurance policy, and I had raised this and I've not seen your policy, but your policy should have a coverage related to officials, employees, et cetera. So you would want to look at that coverage. And typically the way the process works is when a complaint is filed or we're aware of somebody who's making that claim, it's forwarded to your insurance company, which I understand that has been done. I don't know the results of that. We've not yet heard from them. They may be waiting to see if an official complaint is filed. But of course, if you have insurance coverage, in my experience, we have always provided that coverage to the officers and employees of the township who are sued as a part of their official work at the township. In addition to that, I have worked in numerous instances where we do not have policy coverage, and we may have a past council member or official who is sued or made part of a piece of litigation, and we have gone to the board on an official recommendation in those instances to recommend that we think that they should provide legal defense. I wouldn't probably adopt a policy unless it's something that the board really extensively wants to do, because the number of lawsuits is obviously limited, and it's really a fact by fact basis. You might spend more time developing a policy than thinking about the scenarios when this will arise, because you're going to want to sort of think about does the allegations relate to someone in their official function? You know, was there whatever, was there fraud, or there's all sorts of different standards that would come into play as to whether you would want to sort of provide that. And then in addition to that, often with respect to litigation, the township, will be named in that litigation with those other officials. And so you're going to have a general vested interest of protecting your interests, and in protecting your interests and the residents that you serve, you typically may provide that there is a benefit of also providing service to the other officials and employees. There's also two other ones, which they're not legal, but there's a practical one for you to consider, which is what board member and or appointed official will continue to serve for the township if in conducting those services, they are sued and are not otherwise provided representation. If they have to get their own private representation, that certainly poses an extreme burden on them to do sort of what is otherwise probably a voluntary act. I mean, most of you are sitting here with probably minimal stipends related to the hard work and effort that you put into this process. So I think that that's sort of something to think about, especially on your appointed like planning commission, ZBA members, et cetera, who may be named as part of making a decision. Last thing also to think about is really the fact that they've been appointed to serve in a position, and if they were carrying out the duties for the township, then there are provisions in the Governmental Immunity Act that would apply. And so most tort liability is going to be subject to that act. The township and their legal counsel is probably in the best position to assert those for the employees and the officials. And it's very likely that sometimes most of the claims would fall away related to governmental immunity. As to sort of damages, certainly claims related to like what you just saw in North Point for mandamus, et cetera, superintending control, those claims are not directly subject to the tort liability limitations because they're not really damages claims, right? But you would still have an interest in defending them. If they were to have, if they were to get a mandamus against your building official or against your zoning administrator, and you weren't there defending it, that is going to directly impact something in the township. So even as to those claims that are not tort claims, I think that you have a sort of significant public interest in being involved. And most all of the interests in instances that we've had this happen, and again, I think probably spread across the last decade, I can think just to see how I think drafting a policy maybe is not the way to go. Across all of our clients, I can think that we maybe had to go and get specific motions authorizing that expenditure, right? So that you can sort of support the fact that you're expending township budget funds for additional legal expense. It's probably happened 12 to 16 times in the last decade. So, I mean, it's pretty sparing across everybody who's involved in litigation. And I'll stop there, but that would be that's my general sort of response to agenda item number 3. And I do think you're going to want to provide coverage, and you may already have coverage. I don't think that we have a response back yet from the insurance company.
I do see a hand up, but I would like to ask to see if the board has any questions at this point first. So Don, any questions regarding what Chris said?
No, I found it interesting in terms of a policy that that the recommendation is that is not. I guess this is a little off the path, but it goes back. Is there in the PMP manual? Is there a section in there, a code of conduct or anything along those lines that lays out some of the expectations of township representatives?
From what I recall, that is something that's being worked on.
I do also have the same sense of when you are elected, I mean, you obviously are putting time and effort, but you want to be appointed. That also takes time and effort. And so you have a willingness to serve. And in those capacities, it could happen to anyone at any time. And I think that it is a huge deterrent if there is a personal risk for somebody trying to do the right thing. And so I guess, not knowing the details of this specific situation, or I'd have to think of, they'd only be hypotheticals, but my general consent, the general opinion is that serving here, worrying about that action being taken against you, unless you've done something to cause it, shouldn't be a concern. I can think of instances where, that if you're representing yourself as a township official or a member of a board, and something goes over the top, that is just embarrassing or has negative repercussions on the township, then I think, to Chris's point, not having a policy that those have to be addressed on a case by case basis. So,
For example, maybe I represent myself as the president of Williamsburg.
and if that causes irreparable harm to the township, then I think that you've probably put yourself in a position that I'm not sure that you might have to defend yourself in that. You might have some personal accountability for your actions because you've acted improperly and brought some type of damage or diminishment to the township. You just can't have a free for all.
Right.
But I think in the prudent act of carrying out your position and your responsibilities, somebody finds that offensive and files a suit, I don't think you should have to worry about being subject to a personal action.
Cheryl, any questions?
Well, I have some comments.
Okay.
I guess I'm really even not sure why this is an issue. Kim Mangus, if the lawsuit is filed, is being sued, would be sued in her official capacity as the Planning Commission chairperson, and that's an employee of the township. So I would think the township's insurance company would handle the defense of that. Past examples, the lawsuit that I believe Chris referred to earlier, with the bank, I believe Dawn Coons was named specifically also in that lawsuit, if that's the one I'm thinking of, the assessor. And she requested to be, represented or defended by the township's attorney or township's insurance company. And that happened. And then I guess I don't know why this wasn't brought forward in the North Point Farms v. Whitewater Township lawsuit. Ron Pop and Kim Mangus were accused of collusion in one of the counts in that lawsuit. And I don't recall that being brought to the board for a determination of whether they would be defended in that regard by the township insurance company. So I guess I don't know if they were being defended by the township insurance company on that count of the complaint or not. But to me, I agree with Don's comments that, would have a chilling effect on people serving in public office if they thought they were going to be sued for a decision they made, although I believe there's some decisions they can be sued personally for, but I might be wrong on that. But anyways, I don't think it's an issue. If the lawsuit does go forward, then assuming there's any coverage left, because I specifically asked our insurance agent, Paul Olson, when he was here earlier in the year, I specifically asked him what that, I believe we have a $100,000 worth of insurance. And I specifically asked him what that covered. And he said attorney fees and damages. So obviously we don't have any damages with the North Point lawsuit, the original one. What Tom Maher's attorney fees are, I have no idea. So, and has our policy Has it reset because we had a renewal in June? I mean, I don't know. But I would think that if this lawsuit does go forward against Kim Mangus, then she would be defended by the township's insurance company.
Heidi?
I guess I would have to have an answer on, is it considered the same lawsuit or is it a new one? Because then this would be a second claim.
And so I think the insurance company has opined to, I believe both Cheryl and I, as well as Chris Patterson, that originally they thought it would be a separate issue. But after closer review, the underwriters have determined it's the same claim. And so whatever the limits are, the limits are. And if the limits get exceeded, then the funds come from our general fund. And I don't know what the accounting is with Tom Maher. I don't believe the insurance company has been asked to share that. I've not asked, but apparently Cheryl has.
No, I haven't asked.
Oh,
No.
okay.
I have no idea what it is.
Maybe we should.
And so maybe we should ask. Yep. So would that be a proper statement to ask for Tom Maher's accounting?
Yeah, maybe, or just contact the insurance company and ask them
Yeah.
what's been paid.
Yeah,
And if
I mean, that
it's-
seems reasonable.
They may not know if all the bills have been submitted, but
Right. And so I think I'm good here.
I don't think you can really make a decision until you figure out where we're at. Money wise.
Well, I think
we just assume that it's going to be, I think we just, I don't know that we have to make any formal motion. I think it's just, the insurance company has been notified. They know that it's a potential lawsuit out there. It sounds like, they're going to consider it part of, the other lawsuit. And so, I guess they'll notify us if there's not coverage. And then we'll have to decide where it's coming from, as you say, out of the general fund. Sounds
Yeah.
to me like it's covered.
And the reason this was put on the agenda is because it was recommended by Chris Patterson. To make sure all board members received, I guess, information from the underwriter's determination. And again, Chris, I don't recall who all was included on that email string, but I assume the normal principals were. But I can check that. So I think we're all under the understanding that no policy is recommended. We would probably review each individual claim for its own merits.
Yeah, and I could modify that I guess I could modify that a little bit based on the comment about the policy. We could put a policy in place that says your policy is to review it on a case-by-case basis, if you do desire to have a policy.
Sure.
So,
Yeah. I'm agreeable with that. I find that as a reasonable solution.
That way, there's some verbiage in our policy and procedure manual to address it. And then we don't have a repeat of this meeting, for example. Is that kind of your thought process there, Don?
Yeah,
Yep.
you're just discussing the matter, and whatever the course of that decision makes, then it either goes this way or that way.
Okay. And so thank you for being patient, Al. I see your hand is up. Hopefully you wrote your question down.
There we go. What I'm hearing from Chris is he's not sure and we're not sure. So why don't we have Chris contact our insurance company and get us a clear answer?
That'd be a good way to do it.
Well, I think the letter will answer that.
Well, I don't want to think, I want to know.
Exactly.
So
I will- Go ahead.
help me understand your position. I thought the board believes Kim would be covered, right? Did we somehow leave? Kim, you're welcome to unmute and join the conversation. At least, I'm sorry, board. Is
Yeah,
that
I would-
reasonable?
Yes, please.
Yeah,
If she's
okay,
got
please.
questions, she
All
should
right,
ask.
yeah. So did we leave you with a different feeling, Al?
Yes, because at this point, what we have is, we're having, well, I think, well, I'm not sure, I don't know. And, we need to know, are we covered? And if we do something, if somebody does something illegal, obviously they may not be covered. But if we're working in the best interest of the township and our heart is in the right place, I want to know that we're covered. And I'm not hearing that. I'm hearing, well, the insurance company has to make a determination. Well, I guess they need to be specific to us.
And so, Kim, do you want to add to that, or do you want me to respond to Al at this point?
Well, I have some other questions, but I full-heartedly support Al in his question. We don't need, I think probably, we need planning commissioners barring an illegal act are covered. And then in addition to that, if our coverage is $100,000, the average homeowner has more than that on their trailer. That's ridiculous. Unless there's some legal limitation that the township can't be sued for more than that. That seems like a ludicrously low level of coverage. So I guess I agree with Al. We need a definitive statement. And ideally, I'd love to see that in our policy and procedure manual or our employee handbook. Now, I can't speak to the presence or absence of that because our request for a policy and procedure manual and an employee handbook has not been granted. So honestly, for the average planning commissioner, I'm speaking for the entire planning commission as the chair in this regard. Every planning commissioner should be able to see in one of those two documents, A, a copy of the document, and B, that they're covered. That it's safe for them to follow what they feel is the best for the township, because it is not uncommon for us to be put in a position where both sides are going to sue. You're just picking which one you're getting sued by. Our decision should not be swayed by which side of the decision we're most afraid of. That should never be part of our decision-making strategy at all. It's very, very easy to end up in a situation where you have a community group in a project and someone's going to be upset at the outcome to the level of litigation. And we're going to see more and more of that as our township grows, as the area grows, as there's an extreme increase in developmental pressure in the region right now. So Al is right. We need more than a maybe.
So, hearing what you said, and Chris, you may want to follow this and respond. I think the board's position, I know that the board's position is to provide, extend, cover, however you want to label it, legal defense to a board or commission member while acting within their scope of duty, whatever their duties are. So if you're supposed to make decisions on, let's say, marijuana applications, for example, okay, and let's just say that you are the person who decides on marijuana applications. If you decide to turn company 1 down, but choose company 2, you could potentially be sued. So you would be covered, as I understand it, here today. And we could write that in a policy, which I'm not going to wordsmith at this level, but that's kind of what I'm hearing from other boards and or other board members here today, is that we would have a policy, and barring illegal activity, that's the note I made, we would provide coverage.
That's the position I take. I'm in agreement with that course of direction.
But Chris, earlier you said could be case by case. Does illegal activity, in your opinion, cover case by case well enough?
Yeah, I would agree exactly with your sentiment. What I heard from the board is that we are providing coverage to our board members and our officials, and I think may exist. That really relates to whether you have insurance coverage on the claims. It has nothing to do with whether or not you will be provided insurance defense.
Correct. Does that make sense to Kim and Al? The board's going to pay for it one way or the other, either covered through insurance or revenues of general fund.
Mine would be is raise that limit, raise our coverage to like 250,000, because that's, I mean, I got $1 million on my house for legal coverage. So I mean, and then I think, there we go again, but I think I'm happy with Chris's answer. I'd sure like to have him do the research. He knows more about what he's talking about than I do. Have him check with the insurance company, see that these are actual facts, and then raise that to 250.
May I respond? Well, this is a two-way conversation. So Al and Kim, I believe the $100,000 limit was included in our normal policy. And as we learned during policy discussion earlier in 2022, sometimes increasing these limits from 1 to 200,000 is a ludicrous cost. I'm thinking it was like on document storage or document replacement, for example. If we were to have a fire or flood here in the township, I think we have like $25,000 to replace documents. Well, that's not going to cover it. And so to get $100,000 of coverage, it was an astronomical price. Wasn't worth it. And so I don't remember asking about the legal defense fund specifically, about raising the limits of a certain policy provision. We could do that, but I think it's probably going to fall in the same line.
Yeah, just as a quick side note to that, you're talking about our existing carrier, it might be time for us to look at alternatives when in time is appropriate. And this starts to be one of the criteria that maybe we start to evaluate coverages by. So it just, sure. So I would just ask that people kind of keep that as a bookmark somewhere, and then when the time's appropriate, we should address that issue. And
all right. Any final questions or comments for Chris?
I just have one other general question on this. I agree with Al. I'd really like to see the township put this in writing for everyone. I understand if the cost of coverage exceeds the value, that's something you have to evaluate, but I would check a line item on each item, you know, make them earn their commission. But I guess my specific question is, why did the township write off on the completion of 80% of the lawsuit, if the insurance carrier is going to treat this as one matter, one item, that seems like they're just jumping ship and leaving something on the table and bailing out at the point at which they have hit their liability maximum. Did the township board agree to? Yeah, I understand it. On the whole, it's probably best for the township to get out of as much as they can, but it seems like it would have been more prudent if this is one issue that they would have resolved the entire issue and not left something on the table.
Well, it's a different issue.
Well, I don't believe that the complaint was part of, your personal complaint was not part of the original complaint. And I think that's what prompted the insurance company to think it was a separate issue at face value, but upon closer scrutiny, it pertained to the same root. And I'm not sure I fully understand what you're asking of the board, but it seems like anytime I've had an interaction with an insurance company, I have no control over what they decide to pay, how much they decide to pay, and well, thankfully, knock on wood, I have never exceeded my limits. I have no idea what would happen if we exceeded coverage limits, except that I would personally be on the hook for it. And I think that's what the township board has kind of come to understand here with specifically the marijuana complaint. Had we exceeded, and maybe we did, exceed $100,000 of time, of Tom Maher's time, and maybe the township board will have to come up with some money. Is that pertaining to what you're asking of the board, Kim?
Yeah, it just, it seems odd that they stopped short of resolving the entire issue. They should have resolved 100% of this issue. And then a potential new lawsuit would have been a new lawsuit. If it's not a new lawsuit, they didn't resolve 100% of this issue. So it's either two matters or it's one.
You are challenging then the underwriter's second look at whether or not this is one issue or two.
It seems a little bit like, hey, if we leave this on the table, we can settle the lawsuit. Oh, wait a minute. That makes that, if that's another count, we get hit on the other end. If it makes them subject to another $100,000 limit, which is it? They're kind of playing both ends. So I question how that came about. It sounds like when they made the settlement, they thought it would be a separate issue. And when they realized the accounting, they decided it was the same issue.
And all I'll say is that early on, I was a proponent of a countersuit. And clearly
Definitely.
Clearly the business of insurance representing us, their only goal was to end the lawsuit as quickly as possible.
Was to mitigate.
And so, and that included potentially settlement conferences, whatever the case might be. But it was an expedient end to the case.
This may have been quick, but it wasn't thorough.
Yep.
Well, and I don't know, I'm getting the impression that Kim thinks the township paid something
No,
to the plaintiffs. We didn't pay it. There was nothing paid.
I
So
didn't
there
hear
was,
I didn't get that.
well, that's what it kind of sounded like, but
no, it sounds like
I can see it might get
things
that.
weren't finalized. They didn't finish all of it.
all of the counts in the original complaint have been dismissed and there's a new complaint. With a
If all
different
the if all of the counts in the original complaint are dismissed, then this would be a new claim. They can't have it both ways. It can't be the same and different. It's one or the other.
I think they're in charge, the insurance company. So we can banter about it, but
Al?
they're going to decide what they're going to decide.
Yeah, I was gonna say, that's why, you know what, here we go back again. We're back on, I don't know. And I think we've got Chris here. And I think he can look into that and give us an answer. He's the guy to say, he can contact the insurance company and say, look, is this one? Is it two? Are they both settled? Are they not settled? And then get them settled because, and I think we need to get that raised up to at least 250. We need to make darn sure we're covered, or you're not gonna have anybody serving on any board, because who's going to lay themselves out for this? That'd be ridiculous.
I will remind all of the attendees that you are mixing two different questions. The question of will the township pay? I think you have a very good understanding that the township covers your actions as long as they are not illegal with respect to your position in the township. Whether or not we have insurance coverage or whether or not we pay with general funds is really immaterial.
My question back, Ron, is where is that written at? That they're saying that, okay, we'll cover you up to 100,000 and beyond that, we'll take it from another account. Is that written somewhere?
It's in our policy.
It is in the policy? Okay, I'm sorry, I didn't look.
And that policy would be in maybe the April, May packet. I'm not sure.
Okay, I'm sorry.
Yep, no problem.
Is the policy and procedure manual available somewhere? And or could we get a copy as previously requested? Or employee handbook, wherever this is a printed policy, it would be good for the entire planning commission to have a copy of, well, also just the employee rules of what standards we're being held to. Because I'm sure you have guidelines. We just haven't seen them. So I would reiterate that request. And I appreciate the board, clarifying that their intent is to provide coverage to all board members, all board and commission members. Thank you.
Any final thoughts?
I have one. I think we should go a little step further to the insurance company and find out, do they offer riders for certain things? Like, I'm gonna use an example, your house floods and your 35-year-old couch is really worth $5, but they're gonna give you a new couch. Do you have replacement coverage value, or are you getting the $5 couch? I think we ought to look at our insurance coverages and make sure we're properly covered.
Okay, I'm not sure how depreciation applies here.
Oh, it's the same thing with your records, okay? You said it was gonna, we have $25 or whatever you said to make new records. It's gonna be more than that. So normally your insurance company would say, well, if you don't have enough coverage, here's a rider and you can get full replacement value. And I know this exists because it was a deal breaker for which insurance company I was going to take on a house.
Okay, well, specifically, we did address that back in, again, April or May, and the board determined that specifically for record replacement, the cost versus benefit
Right, was too much.
was not acceptable.
Okay, we'll revisit this at budget time.
Yeah, I think so. All right, so Chris, I think we're probably done with you. Not to make it sound bad like that. I apologize, but we do appreciate you being available. If I'm wrong, let's let any board member or PC member speak now, or forever hold your peace. At least until the next time. And then we'll continue with our discussion of 83 and 84 with the PC members. Sound reasonable?
Good by me.
All right, well, thanks, everybody. It's good to see everybody. Privileged to be here. And if you need me, I'm free till I think about 2. So if you text me, I can jump back on board. So thank you.
Thanks, Chris.
Thanks, Chris.
Thank you.
Okay. So I went back to packet page number 4. I apologize. The reason my notes aren't showing up is because they're in the 913 packet. There. So my first question came in at Article 12.10, which should be on packet page about number 7. And it was specifically addressing the 700 square foot floor space and my recollection of a 24-foot minimum width. And this was specifically to, I guess I'll say, limit single wide mobile homes from being placed in every district. I think we relegated mobile homes to their own area within the township. But now, the way our ordinance seems to be written, and I don't know what board removed the 24-foot. I don't know. But right now, if you live in the residential district on your lakefront property, the person that buys the vacant lot next to you has the right to come in and put a 5th-wheel trailer there, as long as it is 700 square feet.
Like I said, need some help.
Well, they can't install it as a permanent fixture.
Yes, they can.
How can they?
It's being done on Bags Road.
Yep, has been for 3 years,
I don't know if it's been 3 years, but
probably 2.
all of 2. Yep,
They got a permit,
yep,
a land use permit,
yep,
and they install, and they hooked up to sewer and water
Yep.
and all that kind of stuff?
yep.
Okay,
Matter of
well,
fact, complaints
it's-
were fielded by this hall regarding the septic system. And,
and is it a camper trailer?
yep,
Then why?
it's a
why
holiday
wasn't it-
rambler
Why wasn't it covered under camping regulations?
because our ordinance, in none of its disarray or organization, doesn't say holiday rambler campers aren't allowed. It doesn't say that.
Nope.
Specifically, it does not say that white and green holiday rambler camper trailers are not allowed.
Why would it?
Just trying to draw
The attention, Cheryl, of how messed up this is.
of how specifics, Cheryl, sometimes work against us. And
That's
so,
a specific.
well, you're always asking for specifics.
Well, you
And we
said
can't-
our ordinance doesn't say that green and white or whatever holiday ramblers aren't allowed, and I'm saying,
So
why
they're
would
allowed.
it?
So that means they're allowed.
I thought it has to be permitted. It has to say it's permitted for it to be allowed.
So,
And if it's not permitted, it's not allowed.
so the use. I agree with your statement with the use. But nowhere in our ordinance does it say your house cannot be, your living use cannot be a green and white holiday rambler. As long as it's 700 feet. That's the only
So-
criteria.
Were there complaints addressed to the zoning administrator?
Yep.
Okay,
Just like our recent land use permit from April or whatever, using a bona fide, non-motorized nature trail as a driveway was
Yeah.
allowed.
well, and Bob has already explained in writing that that was only used to determine setbacks. It wasn't used to determine where the access is gonna be to that property. He's already explained that.
I'm sorry. It was shown on the site plan
And
as
he-
access.
No, it was shown on the site plan as a feature that cuts through the property. Bob already explained that a couple, 3 meetings ago.
I'm sorry, Bob's
So-
wrong. Because there's no other form of access shown on the site plan.
Nope,
Okay,
not
well,
even
we're
that.
not here to talk about that, but so what's your proposed change with the 700 square feet here? Do you have a change?
I
That the
don't.
planning commission can talk about?
Ron, can I
Yeah.
interject here?
No, please, yeah, you guys should have open mics during this,
Okay.
yeah.
An issue. Our ordinance does not permit a travel trailer to be used as a permanent dwelling.
That's what I thought.
Based
Where is
on,
that listed, Kim?
based on 12.10A, a dwelling or other main building hereafter erected in any district shall have a permanent foundation.
And then-
There are no methodologies in place in which a travel trailer of any sort can have a permanent foundation. Now, if you are talking about a mobile home, that would be Article 36, mobile home standards, which also requires a permanent foundation per manufacturer standards. But travel trailers don't have manufacturer standards for a foundation. So that is not a permanent dwelling. There is temporary structure for camping up to, I believe it's 5 months a year that someone can apply for. And in that regard, someone can live on their property on a temporary or transient basis.
I think that's only 120 days.
But
So,
currently, we don't have a standard that allows a permanent travel trailer occupancy.
I will ask you to define a foundation. Because in my world, a foundation is a simple tie down or an anchor. It is a foundation. You do not, this ordinance does not say the foundation shall support the structure. It does not say that at all.
Article 36, each mobile home shall be installed pursuant to the manufacturer's setup instructions and shall be secured to the premises by an anchoring system or device complying with the rules and regulations of the Michigan Manufactured Housing Commission. No travel trailer meets those standards. There aren't standards for a travel trailer. It is by definition travel.
Oh, all I can tell you
Take the
is that
wheels
we
off it.
issued permits on them.
All I can tell you is sometimes folks don't know that there are rules in other locations. And I think something may have been missed. We have mobile home standards. We don't have, other than temporary residency, temporary camping, no travel trailer should be, if it was treated as anything, it would be treated as a mobile home, and it doesn't meet that criteria either.
You have no criteria for a mobile home.
Article 36 in our ordinance.
Al, question?
What do you mean?
Yeah, I had a question there too. Would that be a case where somebody has applied for a building permit and then takes something out and lives in it and just doesn't plan to build? Because
No.
I thought in Grand Traverse County, I might be wrong. You can do that, but you have to begin construction with a year. Could that possibly be what's going on there, Ron? Is they've applied for a building permit, it's not posted and getting around it that way?
Not to my knowledge.
If you look at
Okay.
like Chris was mentioning, you have to look at the entirety of our ordinance. And we do not, nor did we have any intention of listing travel trailers as a permitted permanent dwelling.
So
If it happened, in my opinion, with my knowledge of the ordinance, it shouldn't have and should probably still be addressed.
And so the same argument exists though with single wide mobile homes. You know, there is a need for affordable housing. I get that. But part of our job here at the board level, and I think similar with the planning commission, is we need to provide certain protections to people. And part of that is protecting the value of their land to the best of our ability. And how does a mobile home right next to my $500,000 house, how does that help the situation? And so I don't want to monopolize the conversation on this one topic. This is just a concern for me. And I've brought that concern forward. And I do know that our ordinance did contain at one time a minimum of 24 feet. So I've not been able to find the amendment to the ordinance that changed that. I would like to have a complete list of all of our amendments, which I think we do in Muni Code. So hopefully a second look, that's what I want to say, a second look of those amendments will prove me wrong.
Ron, for reference, I believe it was done at the same time that our mobile home standards were put into place, which would have been an effective date of July 28th of 2017. And that is where mobile homes were added as a use in the RC and Ag district only. It is not a use. It is not a permitted in the residential R1, R2, R3 districts.
So you're saying in 2017, mobile homes were allowed in Ag? And where else? RC?
And the RC. In the Ag and Rec.
It must be in the ordinance because it's not.
And it's in Article 36 of your zoning ordinance.
Okay, I got Article 36 right here. The purpose of a mobile home standard is to establish guidelines for persons and families who choose to live in a mobile home, a HUD, or similar approved structure rather than a conventional single-family home structure that conforms to the Michigan Residential Code. Now you have 3611 A through H. Number F. You can be located in the agricultural RC districts and are subject to all existing regulations. Getting to your foundation part, that's in here too. Hold on. Each mobile home shall be installed pursuant to the manufacturer's setup instructions and shall be secured to the premises by an anchoring system or device complying with the rules and regulations of the Michigan Manufactured Home Housing Commission. There you
Yeah.
have it.
No, well,
Which would also include an
Not
inspection by
necessarily.
construction code.
it's contradictory to that. I would tell you at 36.11 E says that all legally anchored.
Mobile homes shall be exempt from the foundation requirement.
Yes, thank you. My page just went,
That's okay.
so. Which,
So I think there's a lot of work to be done here to make sure we close the gaps, maybe.
well,
Hey, Ron?
Yeah,
Oh, one thing I was thinking when you were saying foundation, foundations, I typically, when I think of one and probably the rest of us, is somebody has dug below the frost line and poured concrete and brought it up. That's a foundation. We need to probably define, if we want to, we may need to want to define what we believe a foundation is, and that would take care of it.
yeah, I think that's a reasonable outcome, Al. Yep, absolutely.
And that could be done, rather quickly, I would think.
But
When
then
it-
there is the exception where if you select the tie down, you are exempt from the foundation requirement anyway. My point is that, if we're gonna start having these kinds of developments in the agricultural district, either site condominiums or private developers who live on 30-acre parcels, we are going to allow a used mobile home to be installed.
Actually, no construction code does not allow a used mobile home to be installed, Ron.
Well, Kim, you must be wrong because we have proof that it happened in 2022.
It may have happened. That doesn't mean it happened legally, because all mobile homes have to fit the permitted requirements of Grand Traverse Construction Code. Only new trailers can do that. Grand Traverse County will only allow a used mobile home, not a travel trailer, if it is being moved within the same district and was permissible at the time in which it was installed. So
Yeah.
for the most part, only new mobile homes can be installed and never travel trailers. So if something got missed, we need to make sure it doesn't get missed again,
we can
because that was
debate-
inappropriate.
we can debate these items all day long, which we're never going to get through the ordinance. All I'm telling you is that, I'm not investigating these things. I'm just driving around the township, seeing these probably 1970s mobile homes being installed. And I'm thinking, when did that get allowed? Now, I'm not trying to be prejudiced against people who need affordable housing. I think we should make room for them. My only concern is putting it next to a $700,000 house is going to be for trouble. That's all. And so,
Well, you say you're not investigating it, but we have your allegations. And we don't have a statement. You haven't asked the zoning administrator, apparently, anything about it. So,
why would you say that? What
well,
leads
you
you
said,
to believe?
you
What
just
leads
said,
you to make that statement?
you just said, I'm not investigating these things.
I'm not. I am
Okay.
simply observing as I drive through the township in which I live. like all of you have the ability to do,
We do.
but must not.
Well,
And therefore,
yeah,
I don't know
But-
how you
but-
don't see these things.
well, you're making a statement, but yet you haven't inquired apparently of the zoning administrator's office.
No,
why-
that's your assumption.
Well, have you?
Yes, I have.
Okay, and what was
It's
the?
allowed.
Oh, here.
Okay, so let's have Bob tell all of us why it's allowed. Apparently, he feels it's allowed under the ordinance. So what is the specific thing? What I'm trying to get to is, and I hear what Kim's saying, but what I'm trying to get to is if there's something, something in the ordinance that the zoning administrator felt he had to allow it, then what is that thing that you're so offended at with this old trailer sitting next to some expensive house? What is that thing that offends you that you think needs to be in the ordinance to prevent that from happening?
So again,
That's what we don't know.
you're making assumptions. I didn't say it offended me. I'm asking if that's what you want to allow. That's what I'm asking, Cheryl. So could I buy?
haven't
if-
seen
if
it,
you had
so-
Okay, but if you had a house here in the township, which you do,
Of course.
could I buy a vacant lot next to you and put up a trailer?
I don't know what the ordinance says about that, and there is a vacant lot next to me. And I'm not particularly concerned about it,
Okay,
you know?
is it for sale?
Yeah.
No, it
kidding.
isn't for sale that I know of. It doesn't have a for sale sign.
Because I've got a 1960s mobile home. I need a spot to
Well,
park.
buy the lot then and put it, see if you can get zoning ordinance permission to put, zoning administrator permission to put it on there.
I
Ron?
The neighbor on the other side of me, the house doesn't look very good and he's got too much crap sitting around, and I'm not complaining about it.
No, I
Because some of
understand.
it was there before I moved there. And I'm not gonna go around and expect everything to be perfect in the township.
I
okay.
totally appreciate that.
So.
And that's what I meant.
Point
by-
order, it's noon.
And that's what I meant by, I'm not investigating these things. I mean, I'm not going around looking for violations. I just don't. But
But-
when something sticks out like a sore thumb, I have to ask, just out of curiosity, how this is allowed. And so that's truly my point.
And if you think it needs to be disallowed, then you need to talk to the planning commission about that and see if there's something that can be put in the ordinance to disallow it. That's the
Correction.
process.
Correction. Correction. That's a board function. So if
Okay.
board members
Well, you haven't
agree
brought it to the
that
board.
they're in, I think that's what we're doing here.
Well, I know, but we're supposed to be going through this right here, and we've spent how long? 20 minutes on this one thing that you saw, and you don't know how it got allowed. So I'm saying, bring something. If you think it shouldn't be allowed, then what is it that needs to be in the ordinance to disallow it? And
That's a
see if the
planning
board will
commission.
go along with it.
That's a planning commission function.
You just said it was a board function.
It's a board function to point these things out, Cheryl.
Okay,
Ron?
I think you
Yes.
have.
Just as a way to maybe functionally make it through this, I understand as we go through all these ordinances, there are going to be things that pop up that, hey, why are we doing that? And there are cross references that you may not be aware of. This particular item is not a change. It's what's currently on the books. If we could develop a board list of items that you would like more information on, or that you would like the PC to look at, that might make it possible for us to get through more of the ordinance that's in front of you.
And Kim,
that
I
might be
will
a way-
Remind you,
I'd help out.
I will remind you that you are asking us at the board to approve this language.
Yes.
So whether or not it's a change is immaterial. You are
Okay.
asking us to approve something that may or may not have unintended consequences. And that's, dealing with ordinances like you guys do time and time again, just meeting after meeting. You have my sympathy, number one. You often get buried in details, just like what's happening to us here. And so, maybe the best thing to do is to generate a list of questions, and that's what the board responds to. And that was really the impetus for this special meeting, which, most of it was consumed by other things, but I totally understand. So Heidi, you had a comment about point of order. So do you have something else to say?
Yeah, I'd like to use the bathroom. Who's that?
And I'm taking 20 minutes to eat my lunch. So
I think we adjourned for a half hour for lunch. After all, normal people that work get bathroom breaks and lunch. We
Yes,
don't
they
seem to
do.
get any of that. And I don't mind working and keep working, but I gotta pee.
I've got just way too many things to do,
Well, here-
especially in preparation for tomorrow.
Exactly.
And so I'm not interested in continuing the
Okay,
meeting. I say
well-
we just call it now.
Here's a thought. We've given the PC some ideas. Okay, what's wrong? You don't want to hear what I have to say? It's okay.
No,
I just-
ideas on what, Heidi? This is the first sentence
exactly.
of the first page of what we were supposed to review.
Exactly, and I
So
have tons
what-
of notes and stuff on it,
And
so
so do I.
then,
And so what
what's
clues
yours?
did
Okay,
we, what clues have we provided to the PC thus far? We have covered,
1, 2, 3, that's about it.
moratorium, and we've covered the legal expense issue. So we got those two items out of the way. But really, the ordinance review, we're just in the first paragraph.
So my thoughts is because the planner will be at the next PC meeting, hopefully, that he could maybe look at some of the things that are on here and make sure they're all right, because I'm still trying to figure out how big a cabin's supposed to be. Does
Yeah.
it say that anywhere in this document?
It-
Because
it
I can't
does.
find it.
It does.
Well, could you tell me where?
I can't tell you where, but I think it's 650 square feet.
12.1.
Commercial
12.10C.
campground standards start on page 86 of
Right
the
under-
ordinance, and private family campground standards start on page 175 of the current ordinance.
Right.
It's also right there, two sections underneath what we've just been beating up, 12.10.
Right, I see that, but I wanted to verify that in the little chart. And in the chart, it just says limit of one site per 2 acres or one cabin per 5 acres. Okay. Guess it can go from point to
I'm
point.
willing to just provide my marked up copies of what the notes I've made on these two amendments to the planning commission. Maybe just every board member does that, and the planning commission can work their way through them. And I don't know another way to do it other than to sit here and go through everybody's questions, which is very, very, very time
Well,
consuming.
that would be fine if everybody puts a date as to when they're sending it. An ending date of when you're sending your requests. In other words, you're gonna do it by Friday, you're gonna do it by Monday, and a date. So that somebody's not hanging out there waiting for the last person to send their comments in. Like, she's not here. She's gonna send her comments in? We don't know.
Do you have a recommendation for a deadline? Is
Well,
that,
if everybody
is
has
that your
already
thought?
done their homework, get it so they can put it on their agenda.
What agenda? Their next
And then
one?
their next agenda, which is coming up pretty quick.
Pretty darn quick. Mhm.
But if they're gonna discuss it, they need to get it on their agenda.
And so let's, for example, continuing your thought and Cheryl's about written comments to the PC. Would we be there at the meeting to address any questions or comments? In other words, maybe whoever reads your comment or your question might not fully understand what you mean. So
Then
I
I might have to bring it back to you.
I think what we're doing is transferring this conversation unfairly to the PC.
Ron,
Yes,
I would like to put out one other notation on that. Were I to receive a list of concerns from each board member and bring that to the planning commission, that would mean we be acting on each individual's notations, not a consensus of the board.
correct.
So that can be problematic. I would like to suggest that perhaps a work session with 2 board members and 2 PC members to sit down and go through all of this preliminary, and then it would still go back to the PC or to the board, just to reference some of these historical questions, some of these foundational questions to move this project forward. And in addition to that, the board also has the option of skipping to Article 25, which honestly, I think is more critical than the one you're looking at right now. You're looking at Amendment 83. Amendment 84 is more time sensitive. It would be helpful on each of those counts. We don't have to do them all at the same time. We can tackle things one thing at a time so that we can start moving this stuff forward. Just putting out ideas.
Thoughts from the board members? You want to break for lunch, come back, deal with 25 first?
Okay, well, let me ask you
Or-
this question. What if everybody sends me their wants and needs, and I'll compose an outline? I'll send it back to everyone.
How does that address Kim's concern about individual responses?
Well, because I don't know how else you're gonna, I mean, it's basically you're taking a survey of everybody's comments and putting it on a piece of paper. And then eliminating, if there's just one, you only take one. If there's 2, then 2 wins. I don't know what to tell you.
Right.
But let's do something, not nothing, to get it on that agenda.
Well, I'm going to make it real quick as far as my comments on Article 25. I'm satisfied from what Chris Patterson said earlier, that a lot of work has been put into this Article 25. I'm satisfied that his office has been involved with it, and that it will serve the township, and I'm not going to have any comments on Article 25.
That's where I think it should be split.
Well, we addressed that, Heidi. We talked about that, Heidi.
Yeah.
We said that for the purposes of this conversation, keeping them together, and I think Chris Patterson gave us a very satisfactory answer for that. That if that, I still think it needs to be split out, but it can be split out at a future date. But for the purposes of moving this along and solving the special use permit or special use language, again, I stand by it. I found it to be very good.
So then you want to leave it as is and split it out. When would you split out to 2? You would send it back adopted and revisit to split the 2? Or are you going to put another article or amendment in there, or how are you going to split it out down the road?
Quite frankly, right now, it should just be tweaked and adopted the way it is. And if, or, I mean, it could just be tweaked and adopted the way it is and later moved to two separate articles. I don't personally see why it needs to be in two separate articles, but, whatever the rest of the board wants to do, we just need to make a decision. I'm starting to get some things I've got to deal with.
Well, it just under the finding of facts, where site plan review contains housekeeping errors, it needs an update. Did we fix it? I'm just asking the questions.
Sounds like a question for the planning commission.
So you're recommending approval of proposed amendment to section 1 and 2 of this amendment, but did you fix the housekeeping errors, Kim?
Doesn't 25 have marijuana in it?
Yes, it does.
Yes.
And it's sticking right in the middle of it. So I don't know why that's sitting in there either, but okay.
So
And I think. the
Marijuana
attorney-
is not in 25 because nothing's been adopted. That's
Right.
where it would have gone.
It's in 12, I think.
So are we taking it out of 12 or are we just leaving it there?
Aren't we talking about 25 right now?
Yes. I'm just trying to look at all the findings of fact and it makes questions. So if it's supposed to be complete, why do I have questions? Even if it's housekeeping errors.
In 25, everything has been done that the attorney felt was necessary in order for it to be fully functional. If the preference of the board is to divide it into two sections, I would ask that you adopt what's in front of you and then send it back to the PC with a request to extricate the two sections from each other. Because it will take some time.
There you go.
and so we could adopt an ordinance that says minimum up to and has terms like that. And then come back and correct known deficiencies. Is that what we want to do as a board?
Well, I would like to see the board get something adopted. It's now been over 2 months since the moratorium was placed, and nothing has been done to address any of the issues for the moratorium. So Chris Patterson seemed to think that this was pretty complete. The planning commission has sent it to us. They believe it's complete. I'm not going to fly spec it. I think we need to get something in place so that those functions can continue in the township.
Do you have a motion?
I didn't bring one and I didn't see any in the packet.
Only motion was on the moratorium.
I'm not making any motion on a moratorium. That's not what he asked.
You get what I said though, right? Okay.
Is 25 amendment number 84, Kim?
Yes. And separating the two articles would require a full readoption of both in their new form. So if there are small housekeeping items, like the item that Ron spotted, where up to should be of, the board has the option of altering those, the fine tuning at this level, or you could send back a list of those items for us in that we'd be adopting it so that the township is in the best condition as possible. And then reviewing and separating the two items. There is more that needs to be done in the entirety of Article 25, Ron, most certainly than what we've done in this amendment. This was only limited in scope to the standards regulating site plan review and special use permit process, not the individual rules. We've already started on campgrounds, which is also in 25. There's more to be done. It's just a matter of divide and conquer.
I have a motion if you want to hear it.
Oh, Cheryl.
Well, I didn't hear a yes. Okay, I'm going to make a
When do we
motion.
have to approve each other's ability to make? a
Well, I didn't
motion?
hear any sound at all, so I didn't know if I had the
Well, we're
floor.
waiting, so go ahead.
Motion to adopt zoning ordinance amendment number 84 as presented.
Motion made. Is there a second?
I'll second it.
Motion made and seconded. Further discussion? Roll call when ready.
Glenn,
Yes.
Goss, yes. Pop,
No.
Valmuth,
No.
Bennett is absent.
And here's why it's no. Because you don't say anything, you just said passing something, you're not adding anything to it. You're just passing this. You didn't say we're gonna relook at it or send it somewhere or. Does that help me understand if this covers us with the moratorium or not? If you just pass it like you just passed it, you didn't put.
It didn't
I guess.
pass.
So.
I understand that, Cheryl, but maybe we just need to make the motion a little better
Well,
here.
Or
That's
or a
your
little
discussion.
different. or
You're a little different,
You can make a different motion,
but
but I'm
I-
going to lunch. It's 12:20. I've been sitting in this chair for more than 3 hours and I am now taking 20 minutes for lunch. The recorder is sitting here. You're welcome to continue the meeting without me. And I am leaving the board table at 12:20 PM and I will return about 12:40. Thank you.
What's your wish?
well, can you just pass something like that? Does it cover, we have a moratorium. So if you
Is your
just,
wish to continue
Oh, I'm-
without the person taking the minutes? Or,
I don't know what to do with her. We just need to either. All I'm asking is, I don't want to pass something and still be in the same predicament we're still sitting here in. Because she just said, we'll pass it, and she didn't say we're gonna relook at it or send it back or anything. So if you have a moratorium on something and we're in this predicament because we weren't detailed enough, that sure hell isn't detailed enough to me.
So would your support for a motion change if we were to each member provide a list of small, how shall I describe it, other than really uneventful housekeeping items is always used, but as I find out, housekeeping items mean we're going to put a mobile home next to you. Okay.
Well, see,
That's a
that's my
housekeeping
problem with
item
just
that
throwing this out there.
I don't agree with. And so maybe if we,
Make a motion that we'll pass it and send it back.
so really what we could do is provide a list of verbal corrections, maybe? How could we describe small incremental changes? Al, is your hand up current? Or
Yes, sir. Yes, sir. Ron, why don't you just put what the changes that you want to see and give it back to us? And then we can look at it, make those changes, and it'll be done.
And what I'm trying to work here towards is adopting with certain amendments, right? So the board members present can provide a list of amendments or wordsmithing
Mhm.
that is desired to accept, right?
I mean, the planner will be in this meeting too, so at least we'll know,
No,
No.
if we
send the list.
vote to accept as amended, for example, right?
Mhm.
Maybe accept as amended concurrent with board members' lists of corrections. I'm searching. Potentially that,
Ron, I had a question if I could.
yeah.
Ron, could you just get those to us, send it? And I'm wondering if Kim, we could just put that as priority number one at the next meeting, make those changes and get it back to you complete? Would that satisfy everybody?
What I would prefer to see is to handle it as two different processes.
Okay,
Adopt what we have, and then with an agreement as part of your motion that all board members will send their concerns to the planning commission with a directive of the board to take up splitting the two sections into separate articles and discussing and addressing each of the board members' concerns. That way you would have the option of addressing the moratorium. You would have the essentials in place in an expeditious timetable. And then also you will have given formal requests to the PC that you're not, we appreciate what you've done, but you're not quite finished yet. We would also like you to address this list of individual items. I think we would get the most done in the shortest time frame in that regard. And not put it another additional months out. Each additional meeting is more months out.
So how you want to put that in 3 sentences?
It's kind of been my question all along. Are we back to making a motion as written, like Cheryl's was, adopting it, and then coming back to making a request at a later date to the planning commission to pick up these items, or these items need to be corrected on a future review of Article 25. Is that,
Well,
I mean, that would.
it solves your issue a little better than just passing the ordinance.
Well, I mean, really, it's Cheryl's motion still that we adopt as written. But then it's almost like we turn around at our next meeting and then say, oh, by the way, there's a list of corrections we want you to make. So,
Isn't there a way to do that at this meeting to get it onto their agenda?
or we could just not adopt this and leave what's in place.
Would they rework on it without direction? No, we have to give
I
them.
took it on good faith that based on what I heard from both Kim and Chris Patterson, that the embedding of special use into 25 as it exists today does not pose any significant risk. If the elements of that are written there, I feel pass muster. However, I did condition it and say that it doesn't preclude us from making a request of the planning commission, whether that be 1 month from now or 6 months from now, to take and strip out
See, I don't
special
wanna
use.
Wait any longer.
but-
This gotta get done.
You're not fundamentally going to be, you might add some things at that point that you've learned, but you're fundamentally taking 26 or 25
25.
and putting it either into 26 or 27. And if that's the motion that's what you want to amend the adoption to, I'm still for that, because I've always been right from square one. And then if there's a question that if you have any housekeeping concerns that you want addressed, I do think that's a reasonable path to send them back to the PC and have them address those, and move this thing along.
So the gist of your statements is approve as written, and then allow each board member at their own will to recommend changes to it for board approval. And then the board's direction to the PC then can be transmitted. For example, I might say, well, I want Article 25.99 removed in its entirety. Well, the board may not agree with me. So I still think it has to be a board decision to,
I see that point. I see that point.
but it's
clearly.
up to each member to bring their concern forward to the board. Let the board chew on that particular item and then make a request to the planning commission. Is that basically what you're saying?
Not initially. I did not think of that unintended consequence. The way you articulated it turned a light on that said, you're right, that there might be something that any one of us would want stricken, and that should be a board discussion. So the way you modified my statement, I think has a better reduces the chances that we're going to find ourselves in a quagmire. At least we've brought it back to table discussion. So.
And I didn't mean to modify your statement. It was just my.
Yeah, no,
understanding of what you said.
I liked your suggestion better than my original statement. So.
Because I truly thought that's what you meant. So then we're right back to passing as written. And I'm fine with, Don has a good point there. Just as I'm going through reading policy manuals and from whenever, because we can't get a newer model, we update those and I bring those to the board. We could do the same thing with the zoning ordinance. We've recognized that there's a statement in one article, whatever article it is, that doesn't read right, make sense, or contradicts with a different provision that might have been missed or might have been part of the discussion. So we bring it up at the board level, we talk about it. If the board agrees, yeah, that doesn't sound right, then we ship it as a request to the planning commission. I think that's a reasonable way forward for me.
That's a solution I can get on board with.
But you are sending this back to them. You're not gonna we're not thinking about this. We're gonna send it back to them.
That's not part of where I'm at today.
Okay, well,
Unless you want to bring a specific concern forward as a board member.
Are you still hung up on the splitting of the special use?
no,
What's causing you heartburn?
I'm hung up out that we have a moratorium and we're just gonna pass something as is. That's where I'm hung up. So if we have a moratorium, I'm gonna look at you two. Has this protected us enough? Or does it need more work? If it needs more work, we should not be passing. We should be sending it back saying, please fix so that we don't have any issues with the moratorium? That's a question I can't get answered. I mean, they say split, they don't say split. You say put a moratorium, I wait, I try. Now I'm in this predicament. Okay, but nobody can tell me if passing this as is, not putting any other attachment to it, that it's gonna get fixed, is still leaving us in the same predicament. Am I wrong?
So I think what I hear you asking, are there requirements have the requirements changed? Earlier, I made a statement similar to, if you have a garbage dumpster, then you need to show it. If you have a sidewalk, then you need to show it. Are you asking that the site plan review or the special use permit require the dumpster, require the sidewalk? And of course, we're using the dumpster and a sidewalk as a metaphor, right?
You're just talking about site plan review. Go on.
So is that where you're at?
I just want to make sure that we have, in other words, somebody's not going to come in and go, oh yeah, I can do this because you didn't X, Y, Z this. Because I'm still concerned that when I start following everything, there's issues. Okay, there's still some issues here, but it's limited in scope. So I don't think the way she worded her amendment or her motion is covering us 100%. And unless we put on a little tidbit that maybe, okay, are you 100% positive, Plan Commission? There's nothing else in here.
So everything that we need for a site plan review is contained in 2510.
Correct.
So it's the zoning administrator or the planning commission as specified in this section. Each action taken shall be duly recorded in the official record by the zoning administrator or the minutes of the planning commission. Those applications which require planning commission review will then be submitted to the planning commission for action along with the recommendation of the zoning administrator. The zoning administrator shall also seek the recommendation of the fire chief, road commission, drain commission, health department, Michigan Department of Environmental Quality, changed to Great Lakes and Energy, or their successors where applicable. You agree with that?
Yep.
Following the approval of a site plan or special use permit application, the applicant shall comply with all other local and state laws, including any applicable permits or approvals.
I never read this till I'm blue in the face.
Well, I'm trying to identify where you think we might be lacking. Because we didn't really add anything.
No.
And so, you know, this site plan review will not really add any protections to anything in the township,
No.
nor was it meant to.
Because of the special use and the site plan review. Okay. It still bothers me. But who does, Kim? Go ahead, Kim.
I'm sorry,
No, sorry.
stay in your lane.
Okay, no problem. Remember, I gotta pee, so let's go.
Well, if you
No,
need to
no,
use the
no, no,
bathroom.
nope, we're getting this over. Keep going.
What's your statement, Kim?
I was just gonna state that, the purpose of this amendment was to divide site plan review and special use permit. From that
Why didn't
perspective,
you do it?
not divide it,
It's a simple-
divide
it's a
the
simple-
standards.
It's a
divide the
simple, I
standards.
forgot.
No,
If it was the intent to divide it, then why didn't you do it?
Ron, they are divided. They simply weren't put into separate articles.
Oh,
There is a separate section that addresses each item individually. Prior to this, what we currently have at the moment is a list of what's required that is conjoined. And it doesn't have a separate list for each item. This amendment does create a separate list for each item. I guess what I'd like to encourage the board is the township, from a legal standpoint, in my opinion, with my experience in the planning commission, is in better shape with this amendment than without it. And I have no problem with the board sending a recommendation that the PC, and I would add the word immediately, begin work on separating into separate articles. Both would have to be readopted, so there would be ample opportunity to address any individual items that the board has in addition to that, and for the board to corporately make a list. So we're better off with it than without it, I guess, is the bottom line.
just out of curiosity, what section states requirements for the site plan review? Just a straight up site plan review. Where are the requirements for it?
You're not going to see it in this amendment because we already have, no, Ron, because they already exist.
Yep.
We already had a comprehensive list of requirements for site plan review. Those are still in effect. What we added was a second list for special use permit. Our site plan review standards were already very thorough. They were so thorough that we were using them for special use permit reviews, where it really should be a second listing of criteria. What we did was we kept the site plan review criteria that we had, and we added special use permit criteria. So you're right, you're going to see almost all the amendment is in special use permit criteria.
So my disconnect with this is when I see a red line document, says black is original text, red is new verbiage, and blue are notes. The original text does not apply, it is not presented in its entirety.
No, the only thing we changed under site plan review was the intro. All of the rules,
Disconnect with this.
all of the rules pick up with B and go on for 4 pages.
So I just explained exactly what my disconnect is with this. I'm believing that when you provide this clean copy, that's what our ordinance is going to read like. And I'm
No.
thinking we've lost our minds.
No, we have only reviewed and amended A and B. Site plan review standards go on to additional sections, final site plan review, required information, site plan, standards for decision, failure to initiate construction, modification, et cetera, until you get to 25.21. There are multiple sections in between 2510 and 2521. There's an additional 5 pages of standards between those two. This is just what's being altered or changed. The intro to site plan review, which is just indicating that we're separating the two, and then a whole new set of list of standards and guidelines for special use permit. We're not removing all of the existing requirements for site plan review.
That was my impression of what was provided and
No.
what we would be voting on.
This is section 1 of the amendment is only addressing A and B. Just the introduction to site plan review. Special use permit is a completely new text. It's all new, everything new. We did not delete everything in between 25.10 and 25.21.
Yeah.
So yes, this protects us more than what we have now. A lot more than what we have now. And we are not removing any of the protections we currently have. We did not include it in this amendment as we had not gone through individually, line by line, gone through those standards. I hope that helps.
I guess then I'll make a motion to repeat Goss's original motion.
What is your motion?
is-
Hold on, could I ask
Okay,
another
yeah,
question?
Yeah,
So just. And I think, you know, my understanding of what we were working with were the corrections to the specific sections of 25 and the addition. However, understanding your point and hearing Kim's, it would seem to me then that the proper point of presenting this should have been inclusive of a completed black line or completed
clean copy.
clean copy of everything, which you could then define as this is staying and this is changing and this is being added versus the cutout
And
of
Paste.
the cutout and then ratifying or certifying what these I can understand how you could, someone could liberally interpret that Article 25 now is this. And that is not what Article 25 is. Article 25 is these changes plus the existing text and probably should have been presented as to one clean copy to take that out of the equation. Is that what I think I'm hearing you saying?
That's
Okay.
strictly where I was.
Okay.
I was thinking that this was going to be Article 25 moving forward.
Okay.
Ron,
Okay.
Yes.
just to address that, that might have been the way we would have presented it. But without a working word copy for the ordinance, I was not going to retype 5 pages double-sided of detailed footnotes and standards with the arrogance to think that I would get them accurately transposed. So we made the amendment to the sections that were relevant. And the rest of it with the understanding that we still have more we need to review, but the remainder and the balance would be better reviewed with a planner. So this is not all of the standards. This is only the amendment to the intro and then the amendment to the site plan review standards section. So I apologize for any misunderstanding with that. Without a working word copy, it simply was not, was likely to cause more harm than good to try to create a new copy.
Okay. So again, I'll go back to an earlier statement. I'll make a motion repeating Clerk Goss's motion to the best of my ability, that we accept zoning ordinance amendment number 84 as presented.
And you're not adding anything on to that. Just gonna leave it, and whenever they get to it, they'll figure it out.
I'm gonna second that motion.
Motion made and seconded. Further discussion, Heidi?
You're just gonna leave it as is and we're covered, or are you going to put something on?
So it's up to each individual board member to bring their comment forward to a future board discussion. If the board understands your point or your change or your proposed modification, that item will be forwarded from the board to the planning commission for them to deal with. That will protect the planning commission from, we'll say the supervisor saying, I don't like section 99. Just to be clear, there isn't a section
I
99.
get it.
Okay, but that'll preclude the potential for me to say, I don't like 99, so I want you to eliminate it. It has to come from the board as a group decision. Majority will rule, and whatever the outcome of that discussion on my particular opposition to section 99, if it gets picked up by the board, great. If it doesn't, then I have to assume it's only my problem with section 99. Now, I can bring my problem with section 99 to the next board meeting, regular board meeting.
Yeah, and then it goes past another PC meeting.
Well, as we've heard from legal, as well as two representatives of the planning commission, that it would be better to have this mistake
Than
than the
one we
previous
had.
mistake we
Right,
had.
We're jumping from one mistake to another. We're supposed to be fixing mistakes, not jumping to new ones.
This is what we're presented with.
And the other question, so you want to bring this back as a motion, and then it's up to each board member to send the PC what they want?
Nope,
No, it's nothing.
no. What part of the past 3 or 4 minutes did I not make
No,
clear?
I get it.
You're welcome to bring any opposition
I get it.
to the board. The board can agree or agree to forward your opposition to a particular provision to the planning commission to be addressed, or it can deny your request.
And I would have to put that on my motion. Right?
Well, I mean, motions are crafted many different ways.
I can't, you guys, I can't go with another mistake. We either have to motion this to fix, or I can't keep making mistakes like this. It's making me crazy.
Okay.
I got too much time into what I did.
I'm ready to vote.
Yeah, and I'll be the first one to vote probably. Go on.
Ron, are you ready to vote?
I am.
Cheryl, did you catch the motion?
Motion by Pop, repeating Clerk Goss's motion to the best of my ability that we accept zoning ordinance amendment number 84 as presented, second by Glenn.
Is that something you feel you can vote on, Cheryl?
I'm gonna vote on it.
Okay. Roll call when ready.
Baumuth,
No.
Goss, yes. Glenn?
Yes.
Pop?
Yes.
So then, of course, this gets sent to, well, I will get a notice of adoption from Chris Patterson. And so that it can be published, and I believe it has to be published within 15 days, and then I think it's effective 7 days after that.
Why wouldn't the planning commission make the notice of adoption? Why doesn't that come from them?
I always get it from the attorney's office.
Do you?
Yep.
Okay. All right. That concludes our business listed for today's meeting. Board comments or discussion? Second, public comment. Anyone in Zoom land? Would you like to make a public comment? Please raise your hand.
You said that was 15 days and 7.
Seeing none,
I believe
how
so.
about here in Township Hall? Anyone wishing to make a public comment?
Connie Highmore. Who, I know you can't answer this question, but I hope that between you all, who has these Word documents that the PC needs to do their work? There should be no expectation that the PC chair should have to retype all this stuff. We have been hearing about these Word documents for, I don't know how long. Somebody let go of those documents to that woman so she can do her job. If you're the person who has them, let them go so she can get this done. You are a stopping point as to why this is a clogged wheel. The comments about ordinance shambles and get your house in order are reinforced by the status of the zoning ordinances and the general ordinances. Read them. Make your own discovery. Here's an example. General Ordinance 26 has amendment number 3 that was accepted and listed, posted in the newspaper. And in the back side of it, the top says it's ordinance 3, and in the bottom it says ordinance number 2. So was 3 not ever adopted because it's called ordinance 2? There's a mess. I get 5 minutes at this podium and you want me to tell you in detail what my comments about ordinances in shambles? There's a perfect case scenario right there. I have a case, a giant case of books that I have studied and hauled back and forth from my hometown back up here, back and forth, and I study them for hours every day. Five minutes, that's what I have. At least I read the packet and the zoning ordinances. Rural is defined in the master plan. You think there's no definition for rural? Read the master plan. Again, I don't expect all members to know that because they don't read and gather facts before they speak and poke at citizens. Rural is defined in more than one of the MTA books. It's not rocket science. It's called reading. Most important than property rights mentioned today are my citizens' rights, not to be attacked by an elected official. Why is this allowed here?
Vicky Beam, resident of Whitewater Township. Cheryl, there is the split. The split has been mentioned since I'm aware of the March PC meeting. And it was brought up that it was done incorrectly. That has been brought up in many meetings. It is past the 4-to-1 ratio, and that needs to be dealt with. Listening to the attorney that was on today, he mentioned that the Supreme Court recognized a need to stop disorderly development. Site condos continue to be a topic that's analyzed according to the attorney. We are less than clear, have litigated in the past. He's received opinions, some changes, and has stated that it had to be clarified. And he too brought up moratorium being in discussion. He actually said since last fall. I saw it in the minutes in December. So I don't think that there should be a surprise, or he's not surprised by that because of the articles that we're in a moratorium. And it has been an issue in this township in the past. See, it wasn't just us. I'm a private citizen. It is none of your business about my splits and what I'm doing, and I am not a developer. And I don't know how many times you mentioned my name, but you are wrong. Do not ever speak for me again, Cheryl. Do not assume that you know anything about me. Your thoughts are not what I think of at all. You are way off. You have no right to put words in my mouth. Keep my name out of your mouth in these meetings. I am a private citizen. I am not an elected official. I am not going to be treated the way that you do your board members. Unbelievable. Unbelievable. Again, split mentioned. We have some paperwork into all of you. There are issues with that split. There are issues with anything being able to happen with that property. Bob mentioned and admitted that he did it incorrectly. And I just want to point out a few things. You all are wanting to ramrod some of these things to go through now because of a moratorium in place, and things are not in as they should be for it to be lifted. Look under 12.12 and 12.13. It says minimum lot area. Is it square feet? Doesn't specify that. Is it 10,000 inches? Has anybody consulted an expert on campgrounds? There's no minimum under agricultural. So I guess under agricultural, which I have property, I could put in as many campground sites as I want to on my property. There are no additional. So this information that's coming to all of you, as Connie mentioned, I feel a lot of private citizens are taking more time preparing than members of the board and members of the PC. It has got to stop. Again, go back to the split. It is more than 1-4, and it has been mentioned in many meetings. Do not mention my name again, Cheryl, in these meetings.
Anyone else in public or in Township Hall for public comment?
Aaron Boyd, 6303 Bags Road. I'm really at a loss of words. I really don't think anything was accomplished today. In the name bashing, Cheryl, if it makes you feel better to call out names, then do it. Because you know what? I stand behind what I say. I have never said that developers are horrible people or evil people, or I don't want development. Never have I said that. I want it done legally, the right way. That property has been divided illegally. Nobody wants to address that, but we're the bad guys. Get your facts straight. If you're going to bring my name into something, make sure you're saying what I'm saying is exactly what I said. And again, it's none of your business what she has as far as property. She bought acreage to live on acreage. not to have 22 houses put in front of her. How is that going with the flow of property? When you have 10 acres here, 20 acres here, 50 acres here, and then we're gonna have what, acre lots in between? That's not going with the flow. Rural character, look it up. Again, if you're gonna bring my name up, make sure you get the facts straight.
This is unprecedented, but could I ask for a clarification from a public comment?
Yeah, go ahead.
I would allow.
Cheryl?
No. But do it anyways because you have a majority.
Okay. Karen, could you come back to the microphone just for our folks on Zoom, please? I apologize. You made a statement that certain things don't go with the flow.
Mhm.
And you made a visual representation of large acreage properties and then something very small.
Mhm.
And so going with the flow is, do you mean characteristics of adjoining properties?
Correct.
Is that what you meant?
From what
by
I
going with the
understand in the
flow?
master plan, that's
Okay.
what it's directing towards.
Okay.
That
I
the
just-
property should have a, you know, if you're gonna have subdivisions, then have subdivisions. But why would people buy acreage if they knew that there was gonna be 23 houses or 22 houses put in front of them?
No, I just wanted to clarify for my own, I understand. And thank you.
Mhm.
Thank you, board. Welcome. Anyone else? I still see no hands up at Zoom, so I will ask for motion to adjourn.
I'll make a motion, we adjourn.
Second.
Motion made and seconded. Further discussion? Roll call when ready.
Pop,
Yes.
Balmuth,
Yes.
Glenn,
Yes.
Goss, yes, Bennett absent. Oh, I'm sorry, Glenn. What's your, didn't I skip for you? Go ahead.
Yes.
Thank you.
At 1:04 PM. Thank you all.